Recording in progress.
Good evening and welcome to the Land Use Committee. My name's Allison Leary and I will be the acting chair this evening. First, I'd like to introduce the Planning Board this is a joint meeting between Land Use and the Planning Board this evening. So I'm going to ask the chair, Mr. McCormick, to introduce his committee.
Thank you, Chair. So I'm Kevin McCormick, Chair of the Board, and with me is Ed Daly, Vice Chair, Amy Dane, Lee Breckenridge, Peter Doringer, and Jim O'Connell. And Katie Weirwall, ex officio. Thank you, Chair.
Okay, you're very welcome. So let me introduce members of the committee. In the chamber with me this evening, Tariq Lucas, City Councilor at Large from Ward 2, Randy Block, City Councilor, the City Councilor for Large from Ward 4, and behind Mr. Block, I see Stephen Farrell, Councilor from Ward 8, and Sean Roach, Councilor at Large from Ward 6, and I'm the at-large Councilor from Ward 1. And let's see who we have online. I see Councilor Greenberg, the Ward Councilor from Ward 1. Welcome. Councilor Susan Albright, at large from Ward 2. And Councilor Pam Wright, at large from Ward 3. And also Cyrus Damabed from Ward 4. Welcome. Not a member of the committee, but all of you are welcome. And President Oliver, welcome from at large from Ward 1. And members of our team here with the city, we have Senior Planner Sandria Berman. Welcome, Sandria. We have Mr. Temple, Jonah Temple, our attorney. Kat Kemet from the Planning Department. She's the Acting Chief Planner for Current Planning. And Zach Melcher, one of our newest staff from the Planning Department, and he's a planning associate with the city. I believe that is everybody. I haven't missed anyone, have I? Okay. So let's get started with the first item. It is my intent to take up the request for 148 California Street. There's 3 separate items, as the committee knows. I intend to take all 3 of them up because they're all sort of integrated and it makes sense to talk about them. But let me read them into the record. This is 7126, and this is KF Realty Trust petition to rezone 148 California Street in Ward 1, Newton. And the next item is 72.26. This is KF Realty Trust, and this is seeking a release from the restrictive covenant at 148 California Street. Then the last item is 7026. This is a request for a special permit to allow for shared parking at 148 California Street. So my plan here is to ask the Planning Department to give their presentation first, followed by the petitioner presentation. Then we will open the public hearing, and then it will come into the committee. Okay, so let's start with the Planning Department.
Thank you, Madam Chair. I'm going to go ahead and share my screen. Just bear with me, and I apologize for the sound of my voice. I'm just getting over a cold. Hope everyone can see my screen. It should be coming up shortly. Okay, see if I can minimize that further. Okay. So again, good evening. Sandria Berman, Senior Planner for the City of Newton, and I will be sharing the planning presentation for 148 California Street, which includes here a set of 3 petitions described as Petition 71-26, which is a request to rezone 148 California Street from a manufacturing district to a business 2 district. Petition 72-26, a request to repeal the restrictive covenant adopted by Board Order 162-88. And finally, Petition 70-26, a request to amend Special Permit 318-22 to allow a 1/3 reduction in the total required parking. So we just have an overview slide here. Based on the information that was presented to the Planning Department, the petitioner's primary request is to obtain a rezoning and repeal of the covenant. Planning notes that while these are distinct requests and require separate approvals from the Land Use Committee, that these two items work in concert with each other, and a change to one item would influence the other. Per item 3, if the rezoning and repeal of the covenant were not approved, the applicant is requesting to amend the existing special permit 318-22 to allow for a 1/3 reduction in parking. When considering the items as ordered, planning notes that a decision to rezone and repeal the covenant would dissolve the existing special permit relief for non-conforming commercial uses and parking requirements, and remove the requirement for site plan amendments to the restrictive covenant each time a change to the site plan is required. And finally, not to approve a rezoning and removal of the covenant and instead consider amendment to the existing special permit. Planning notes that the special permit relief would remain for existing and future non-conforming commercial uses and site plan changes. Parking would be reduced to 519 stalls from the 779 that are required. And any changes to the site plan or uses would require legal amendments to the covenant as well. Just an aerial map overview of the site. The subject parcel is located at 148 California Street, is a 523,642 square foot parcel that straddles the Newton and Watertown border. Approximately 45%, 231,486 square feet of the property is located in Newton and is zone manufacturing. The remainder is located in Watertown at 171 Watertown Street. The site is improved with a multi-building shopping center that includes various retail, restaurant, and personal service uses, as well as office space and surface parking. The majority of the parking is located on the Watertown portion of the site, south of the masonry building. The overall topography of the site slopes downward from Watertown Street towards the shopping center structure towards the California Street frontage. The zoning in the surrounding Nonantum neighborhood is mixed, with abutting parcels to the west and south zone public use, multi-residence 2 and business 1, and parcels to the west and north zone manufacturing. Surrounding uses are mixed, including 1, 2, and multifamily residential dwellings, and commercial and manufacturing uses, including retail, restaurants, and factory production facilities. Just go back there. I apologize, I skipped a slide. In terms of the zoning relief, again, a rezoning request from a manufacturing district to a BU2 district, to repeal the restrictive covenant, and finally to amend special permit 31-22 to allow for a 1/3 reduction in the total parking. In terms of criteria for the rezoning and the repeal of the covenant, the City Council has significant discretion to enact any zoning amendment that bears a rational relationship to a legitimate public purpose. In making this decision, the Council can consider the following considerations: the most desirable or appropriate use of the land, considerations of surrounding zoning districts, uses, density, and transportation options, and if they're complementary or consistent with the zoning proposed. Sorry about that. Finally, criteria for special permits. We have the standard 4 special permit criteria that applies to the special permit request for a 1/3 reduction in parking. The site is an appropriate location for the proposed reduction in parking by up to 1/3, that the proposed reduction in parking by up to 1/3 will not adversely affect the neighborhood, that there will be no nuisance or serious hazard to vehicles or pedestrians, that access to the parcel is appropriate for the types and numbers of vehicles involved, and finally, that literal compliance with the required number of parking stalls is impracticable due to the nature of the use or the location, size, depth, width, shape, or grade of the lot, or that such exceptions would be in the public interest or in the interest of safety or protection of environmental features. Sorry about that, folks. In terms of a planning analysis for rezoning and repeal of the covenant, a rezoning to a BU2 district reconciles the discrepancy between the underlying manufacturing zoning and the existing non-conforming commercial uses, and it removes all parking requirements for said commercial uses as outlined in the ordinance. A removal of the restrictive covenant removes the requirement that the site plan be amended each time any changes to the site are proposed. Planning notes that the covenant was enacted in 1988 when the Newton zoning ordinance included parking requirements for commercial uses in business districts to further codify that the site plan would be able to meet said parking requirements for the requested extension of that commercial use. The current NZO, however, does not require parking for commercial uses in a business 2 district. Finally, a rezoning to a BU2 district and a repeal of the restrictive covenant would better align the zoning with the existing commercial uses of the site, allow additional options for residential, commercial, and civic development use, and finally, that the dimensional standards for buildings in a BU2 district and a manufacturing distance are in fact similar, but noting that a business 2 district offers expanded relief by special permit. In terms of planning's analysis for the special permit amendment request, a 1/3 reduction in parking to require 519 stalls where 779 are required would support commercial businesses by reducing permitting regulatory barriers, increasing commercial sustainability. The proposed parking reduction would reflect the economic priorities of the Zoning and Planning Committee, as well as the recently released Economic Development Strategic Plan to support the city's goals of supporting commercial businesses. That the city's zoning study on California Street also recommends sustained commercial use for this site and surrounding area, and a reduction in parking requirements would enable businesses to meet parking requirements without requiring special permit relief. And finally, that the parking study provided by the applicant notes that assuming all storefront and office spaces are occupied, the parking demand for peak visitation periods is not expected to exceed the 540 stalls. That concludes the planning presentation, and I will turn it back to you, Madam Chair.
Thank you very much, Ms. Berman, for that comprehensive analysis. So I will ask the petitioner to please come up and present to the committee. And you would please just state your name and address.
Good evening. Is this good volume?
Yes, I can hear you well.
My name is Frank Stearns. My business address is Holland and Knight at 10 St. James Avenue in Boston. I am here tonight on behalf of the property ownership, KF Realty Trust. Joining me in the chamber is Jessica Kleinberg, the owner's representative, and our parking study professional who performed some parking study analysis for us, Kirsten Braun, is on Zoom and available for questions at any point. So I really want to emphasize the reasons for these petitions. We want to allow the types of uses that are normal and customary for a commercial property of this nature. The property has a fascinating history. The mill was built in 1880s. It was a mill. It was very industrial uses at the time. So when the city first put into effect zoning in the early 1920s, it was kind of natural that they would put this property into a manufacturing zoning district. And it stayed in a manufacturing zoning district essentially forever. It's in a manufacturing zoning district today. And the mill building, for those who are familiar with the property, is facing on the California Street side. Facing on the Watertown Street side is a retail building that was built, it was conceived in the late 1950s and built in the 1960s. Many people in the area remember it housing, I think, Zayre's or King's department store, and it became the Stop and Shop today became a supermarket. And in the late 1980s, there was an older building on the site, an outbuilding that was demolished that made way for the extension of the retail building that used to just basically be the footprint of the Stop and Shop, and which now extends down CVS, the smaller retail tenant uses down to the restaurant at the corner. That space was added in the late 1980s. But by keeping the property in the manufacturing zone, basic retail, restaurant, and personal and business service uses are not allowed by right. They're treated as non-conforming uses, and it's created over a long period of time the fact that when we change tenants in the existing buildings on the property, particularly in the retail-facing building, from one zoning category of use to another, we have to come into the city council and get a special permit to change from one lawful pre-existing non-conforming use to a different lawful pre-existing non-conforming use. By way of example, CVS, Edamame Restaurant, Planet Fitness, My Salon Suites, and the nail salon, all of those businesses at the property today have special permits for their use because they replaced different uses. And for decades, there's been no manufacturing at the property. The mill building is primarily occupied as an office building, which is an allowed use. It is a allowed use. But the My Salon Suites, which is on the ground level of the mill building, required a special permit because it's a service use. So again, the goal of these petitions is to cure for the fact that the manufacturing zone the allowed uses in the manufacturing zone are too restrictive in our view and not appropriate for a site like this one. We really would like a more efficient pathway when we have vacancies and we're approached by businesses that want to move to Newton and want to locate in the center. If we have to tell them that we're in for a 5 or 6 month special permit process or parking waiver process with the city of Newton, it often is a discouragement for them to move forward and show interest in the site. I think the planning department presentation gives you a fully accurate description of the site: 12 acres with the Newton and Watertown line cutting through it, the mill building, the retail building. The other thing I'd like to point out that a lot of the studies done for the city and by the city's comprehensive plan, the city's recently economic development initiative at the end of 2025, which was published, both of those plans speak very directly to making an effort at appropriate locations to make it easier for businesses to conduct business in Newton, make it easier for landlords to attract businesses to their properties, make it easier for those businesses to come to Newton and open. It's not only, so let me make one other point that's related to the petitions, which relates to the parking. So placeholder for the moment in your minds, all that I just said about the uses. The site, as we all know, has like 685 parking spaces. A good chunk of the parking lot is underutilized. We have plenty of actual parking, no question about it. We know that empirically as the property ownership. We never get any complaints from our tenants, from the customers of the tenants. And we validated that with a parking study by a parking professional that shows we have hundreds of surplus parking stalls, practically. What's really odd is if you open up the Newton zoning code parking formulas and you take each and every use that's there presently, and you add up all the square footage and all the employees, and you do the math, it shows sometimes that you're at capacity. You're reaching the zoning, you're reaching the peak where the actual supply is deemed not to meet the zoning demand. And one of the frustrations that we had, in addition to bringing in tenants, we wanted to make the office building, the mill building, more attractive to office users. So we told the city we wanted to build a little pocket park by the mill building entrance. We had to take away 11 parking stalls, and we were going to build a little pocket park with benches, with landscaping, place that would be seen as a reasonable amenity that if a business came to locate their business in the mill building, their employees could have lunch there and sit out there on a nice day. Fine. The city cooperated, don't get me wrong. Because we were eliminating 11 parking stalls, we had to go through a full special permit parking waiver process to get permission to remove 11 parking stalls. That's part of the frustration. The other thing that happens, and again, everybody's doing a wonderful job in the city, in the planning department, in the building department, city council. If a tenant simply wants, if a new tenant comes in and they have the right zoning and they're building out they go to the ISD for a building permit for their tenant improvement, um, the property is flagged as one that has a special permit on it, and it's flagged as a site that has parking waivers on it. So the tenant who has an architect and has stamped plans and wants to get going on building out their store has to call us and say, but we have to provide the city with updated parking calculations to justify that we're not, that we're respecting the parking waivers and that we're respecting the restrictive covenant. So that too adds to the burdensome nature of trying to operate the existing center. We have been asked multiple times in the preparation of these petitions by city councilors, by neighbors, by others, are you proposing development? And the answer is no. We're not proposing development. We're not proposing to build anything. We're not proposing to change the parking lot. We're proposed that the goal behind elimination of the restrictive covenant is to give us the flexibility as a reasonable and rational property owner to make improvements to the parking lot that are appropriate with site permits. If we want to work with Stop and Shop on cart corrals, if we want to do lighting changes, if we want to do landscaping changes, we don't feel it's real. We feel that it's burdensome to have to come to the city council for a full special permit process in the nature of amending the restrictive covenant. The history of the restrictive covenant is that in the late 80s, when the ownership proposed that small enlargement of the retail building, I would say that there was some unnecessary concern that because half of the parking lot was in Watertown and the municipal line ran through the parking lot, that somehow that created sort of what I'm going to call like an artificial perception of an issue with respect to the adequacy of the parking. So at the time the ownership was asked to agree to this restrictive covenant, which we see as really having no continuing value today, given that there's ample parking spaces. So to wind down on our presentation, I do want to speak to, I think that the chair did an excellent job in the planning department of explaining that it's 3 petitions. The rezone to business 2, which by the way, was something that we've thought about for many, many years. We've talked to the city about at various times, and it was really the city that encouraged the owner last year to convert the property from manufacturing to one of the business zones, and the business 2 seemed like the most appropriate. The shared parking special permit was something that we would see as lowering our burden. And yet what happened at the very end of last year on a citywide basis is that this council, your predecessor council at the end of the 2025 term, modified the zoning citywide with respect to eliminating zoning parking minimums in the B1 and B2 zones for commercial uses. We have only commercial uses, so we can benefit from that. If this council sees fit to approve the rezoning and eliminate the restrictive covenant, I don't think we need to pursue the shared parking special permit any longer. If by any chance the city council doesn't want to modify the zoning and wants to keep us in the manufacturing zone, then we would revive our interest in the 1/3 reduction in the zoning parking minimums, because if we stay in the manufacturing zone, we're still subject to parking minimums, and we have hundreds of surplus parking stalls and don't really need that burdensome regulation. So that's really the description of what we're proposing, why we're proposing it. And again, I know that this is a sensitive issue for some. There is no present intention to develop the property. We have considered developing the property at various times over very many years. The family that owns this property has owned this property for quite some time. It's operated as a stabilized asset with the existing buildings, the existing leases. We want more flexibility when the leases turn over. And anything significant that we would ever propose, if there is ever a proposal to redevelop or develop the project, the site, would clearly be subject to Newton's full-on special permitting requirements, and we would have no objection to that. We would understand that, and we would be subject to that at that time, if that time ever comes in any of our lifetimes.
So, Mr. Stearns, I'd like to bring it into the committee. And if you would make yourself available for any questions, that would be
Okay.
helpful. Okay, so are there committee members that? Oh, thank you. I'm going to open the public hearing. Are there any members of the public that would like to comment on this item? Please come to the microphone. I'm sorry, I can't hear you yet.
Sorry, thank you. My name is Anthony Donato. My family owns property on my,
Mr. Donato, could you get a little closer to the microphone?
Sure.
Just I want to make sure everyone can hear you.
thank you.
Okay.
It's Anthony Donato.
Really have to bring it
Family
closer
owns
to your mouth. There you go.
property on Los Angeles Street. This is the first I'm hearing about any repeal of a special permit, and as I listen to it, I don't understand how that benefits anyone. I want to let you know that there wasn't a butters meeting last Thursday, I believe. It was held outside Stop and Shop. No place to sit at 5 o'clock at night. First time I've ever been to such a meeting outside. I understand that what they're proposing to do is go to the business too. My only objection to that is the gentleman who was there from zoning indicated that if it went to business too, under the present zoning, they could develop all of California Street, which I'm going to guess is 500 feet minimum for residential housing, at least 2 stories high. I believe that the petitioner has no intention of doing anything at this time, which is what their letter said. However, I believe that if you allow any of these, there's going to be quite a few people who are going to be knocking on the door with proposals to purchase the property. So I respectfully request that you look at, if you're intending to grant this, that we look into what the zoning will allow as soon as that is granted. And if in fact that it allows 2-story housing, residential, the entire length of California Street, this property is going to be sold in the very near future. Thank you.
Thank you very much, Mr. Donato. Yes, I was at that meeting with you. It was outside. We wanted people to get a look at the parking and the buildings around there. And the special permit is regarded to the parking stalls. You heard the explanation about how the 3 items work together. So we will take that up and take your comments under consideration. Thank you very much.
Thank you.
Yep. Is there any other member of the public, either in the chamber or online, that would like to comment on this item? I'm not seeing any hands online. I'm not seeing anyone in the chamber. So let's take it back into committee. Councilor Block.
Thank you, Madam Chair. I want to ask both petitioner and the planning department and our legal department about the structure of this conversation this evening. I appreciate the petitioner's explanation. And I want to draw our attention to the planning department's language in its presentation. If a rezoning and removal of oh boy, I can't even read my own handwriting, of the covenant is not approved, then the applicant seeks a special permit. So is the application for a special permit before us, or is the application dependent on whether the rezoning and removal of the covenant is approved or not approved? And I ask that because if the petitioner had asked for the rezoning and the removal of the covenant, our rules would have that referred to the Zoning and Planning Committee. If
Yes.
the petitioner only submitted a special permit application, that would clearly be referred to this committee.
Correct.
The fact that they are both, that all of this is presented at the same time has me puzzled, because how can we act if we don't know whether the rezoning and the removal of the covenant is approved or disapproved? We have to make some assumptions, I suppose, that it's worth our time and that we have jurisdiction over the special permit application. And we only have that if the rezoning and the removal of the covenant is disapproved. And that's only going to happen if the full city council takes a vote and disapproves it. So that's why I'm a little puzzled. I appreciate the petitioner's explanation about their business concerns. I'm very sympathetic to that, and I think we ought to figure out a way to grapple with it. But I'd like some clarity regarding whether the special permit petition is truly dependent on a decision about the zoning and the covenant, or if it isn't. And if it isn't, then I guess, I mean, anybody is free to file whatever petitions they want. So it's just an odd situation that we will have to grapple with the special permit application, assuming that the rest of it fails. So that's my question that goes to both the petitioner, and if the petitioner's intent is to have the special permit dependent on a decision regarding the covenant and the rezoning, and what legal advises us and how planning has thought about this. Do you understand
I do. I
my
think,
concerns about this?
yeah, I think you had an email about that.
Yeah, well, yes, but there hasn't been a discussion about this or an explanation regarding how these three petitions are interlocked, because they're not interlocked in the typical way in which we receive a zoning change petition and a special permit petition.
I would say that in the past, yes, usually a zoning change and a special permit are mostly around a project to do that. So this is a little
Well, it isn't.
orthodox.
It isn't just that it's around a project, it's that
A
the
building.
special permit requires the zoning change. Otherwise,
Well,
the
the
exist,
permit would be no action necessary if the other two items were approved by this
Sure.
committee.
okay, so those are my questions right now about how we should structure these three petitions and and how we as a committee should proceed to consider them. Thank you.
Perhaps would it be helpful to hear from Jonah Temple on this? Mr.
Yeah,
Temple?
Chair, I'm happy to chime in, and I appreciate that this is not the traditional combination that this committee sees, and that it is a little more complicated than normal. But I would say, to answer kind of some of your questions from the beginning, Counselor Block, the special permit request that is before you is the special permit amendment that would be necessary if you do not grant the rezoning and the release of the restrictive covenant. So it is in some ways a request in the alternative. My recommendation to this committee would be to first focus its deliberations on the rezoning request and the release of the restrictive covenant request. And then there are two options from the committee. They could vote those two out with a recommendation and hold the special permit request in committee. Or if you wanted to, you could then take up the special permit and vote them all out together, with the idea that the special permit recommendation is really in the alternative and would ultimately probably get withdrawn if there's favorable action on the other two requests. So hopefully that answers your question, but I'm happy to get into it a little further.
Counselor Block, are you satisfied with that answer?
Well, I understand the options before us.
Okay.
I think Does the chair really expect us to spend time on this special permit tonight? You're going to try and have us consider all of these, even though if we in the city council approve the rezoning change and the removal of the covenant, that the special permit would likely be withdrawn as Mr. Temple
Counselor Block,
said.
I'm certainly willing to discuss each item individually in committee. I just thought it was easier to present them all at once, and since they are integral and together, and it's clear if the first two pass, the special permit would be null and void. So I'd be happy to have you start with that we discuss the zoning request.
I'd appreciate more of an explanation of the covenant. Why a covenant was asked for initially, what the pros and cons are of the covenant. And I'd be very interested in the zoning of the Watertown side of this. I didn't see any reference to the Watertown zoning in any of the documents. Maybe I missed it. And if I did, please, draw my attention to it. And I'd like to know how the Watertown zoning requirements, whatever they are, interplay with the Newton zoning requirements. So those are my just general requests for additional
Okay.
information.
We did not bring up, you didn't miss anything. We did not work with Watertown specifically or get information about their zoning. We did have a discussion, a little bit about that at the public meeting on site. And I'm sure the petitioner would be happy to go into more detail regarding the covenant. And if the planning department wants to weigh on this as well, that would be fine.
Well, I'd especially like to hear from the planning department regarding both the covenant and the corresponding zoning on the Watertown side of this property. Thank you.
Very, very well. And Mr. Temple, would you be the person to talk specifically about the covenant? Would that be more in your jurisdiction there?
I think between us and planning, we can do it together.
Okay. So please go ahead and answer Mr. Block, Counselor Block's questions regarding he'd like more information about the covenant. I do know it was back from 1988 and it worked to give the city a little bit more control and notice over what happened in that parking area where most of it is actually in Watertown. And but please go into more detail.
Yeah, Chair, I would recommend maybe letting each party speak to this. So maybe hearing from Attorney Stearns first and then Ms. Berman, and I can speak to it after that.
Okay, very well.
I'm happy to speak to it from the owner's perspective. So in 1988, when the supermarket existed, but the strip was being proposed as an extension for more retail, the Board of Aldermen, the predecessor to the City Council, identified the same observation this council's making, which is that half the property is in Watertown and that the municipal line goes right through the parking lot. We believe that there was a concern that how could you have legal parking stalls that might not, they're supposed to be 9 by 19 and up, and not be in setbacks to the property line. There was a sort of concern, which I think was grossly overthought and overstated, that you can't really have lawful parking stalls all along the municipal line. I think the Board of Aldermen at the time overcame that perception of an issue by asking the ownership at the time to agree to the restrictive covenant, which essentially says the site plan as it existed then, the number of parking stalls, where they were striped, how they were striped, the interior landscaping, the lighting, the cart corrals for the market, that the site plan shall be locked in, and that any changes to the site plan in Watertown would involve coming back to the Newton City Council for permission under the restrictive covenant, essentially. And further to your questions, Councillor Block, the Watertown zoning is limited business right up against the Stop and Shop and closer to the building entrance, and is two-family zoning at the top of the hill up on Watertown Street. So if we were ever, which we're not, to propose development in Watertown under the current zoning, maybe we could build a little like addition to the Stop and Shop, in theory. We don't have Stop and Shop's permission to do that. We don't think we would get Stop and Shop's permission to do that. We think they like their store exactly as is. So what we have done, dating back to 1988, is whenever we come into the city council for a extension of a non-conforming use special permit, like putting in CVS, putting in the Edamame restaurant, the nail salons, which, the retail uses, the retail type uses that are not allowed in manufacturing, we have coupled the special permit request with a request to amend the restrictive covenant to reflect any changes to the site plan that may have taken place since 1988. And I guess from our perspective, it really accomplishes nothing. It really doesn't benefit anybody, doesn't accomplish anything, and it represents an impediment, sort of an impediment on our title, and doesn't really give the city of Watertown or the city of Newton further land use review authority over what they already have by virtue of their current zoning and the special permitting in particular in Newton.
Thank you, Mr. Stearns. Ms. Berman.
Thank you, Madam Chair. Excuse me. I would largely concur with Attorney Stern's description of the origin of the covenant. A review of the archival application materials from Special Permit 162-88 shows that the covenant was proposed by the petitioner at the time. I think largely because they were requesting an expansion of a non-conforming use, and the parking requirements based on the Newton zoning ordinance at that time were would require substantially more parking. So I would imagine that this restrictive covenant was put in place to ensure that the site and the parking on site specifically was going to be met across the site, including the Watertown parcel. So I think in terms of the covenant itself, right now it still serves as an agreement with the city that the site will remain as depicted on a site plan referenced in the special permit. And so any changes, as Attorney Stern mentions, to the site, no matter how small, requires an amendment to that covenant and that agreement. So I hope that sort of answers some of your questions. I don't know if Attorney Temple wants to speak more to the legal side of the covenant agreement.
Yeah, I will just echo what they both just said, and I agree with it, that it seems for the most part that the restrictive covenant was really an unnecessary belt and suspenders approach at the time. Under Massachusetts zoning law, you're allowed to meet a parking requirement that a Newton property has under Newton zoning through parking that exists on a split lot in Watertown. So we already controlled and locked in the full site plan through the issuance of the original special permit. So there really was no need to further lock it in with the restrictive covenant. And that's really evidenced by the fact that any time there's been a change to the site plan, not only is it requiring an amendment to the restrictive covenant, it's also requiring an amendment to the special permit. So the restrictive covenant never added, it was really duplicative in terms of its layer of control under the existing ordinance to date.
Thank you very much, Mr. Temple. I just want to say that we've been joined by Councillor Maliki online. President Oliver, I see your hand up. I'm just going to go through the committee first, and then I'll be taking it to the rest of the city councilors. Is there any?
I just had a clarifying question on that specific topic, but I can hold it if you want. That's fine.
Okay, thank you very much. Is there another member? Councillor Lucas.
Thank you, Chair. I guess my questions are for planning right now. it would be helpful to know what are the different uses that are allowed by right in the BU2 zone compared to the manufacturing zone. I guess we don't need this information right now, but assuming we hold this item and take it up at a later date, that would be helpful just to see, just to contrast and compare. But I do have a question it was something written in the memo. And it says, furthermore, the BU2 district provides more by right options for residential, commercial, and civic development, wherein the current manufacturing district, all residential uses are prohibited and only select civic and commercial uses are allowed by right. It's the fact that its BU2 district provides more by right options for residential development. I've always been under the impression that it's a special permit for residential development in the BU2 zone. Is that not right?
If I may answer, Councilor Lucas, you are correct in the sense that residential development by right at the ground floor is not allowed. So you are allowed to have mixed use in the business use district above the first floor. So you could have residential, you could have first floor commercial and then second floor residential. And then by special permit, you could also have ground floor residential uses as well. But in terms of the by right option, technically speaking, you could have residential on the second floor. So you are correct in what you said. It's just the second floor it can come in to play.
Okay, but then I'll throw in the twist of any development greater than 20,000 square feet automatically requires a special permit, right?
I believe so, yes.
So with this site right here, wouldn't this automatically trigger a special permit if you're planning to do residential on the second floor anyway?
If it exceeds the 20,000 square foot threshold, I would say yes.
Okay, all right. Oh,
I think if you were doing new development, yes, but I think if you were utilizing the existing building, I'm not sure where the line is. I also have the use table up. And I think where we hit the roadblocks between manufacturing and business are around personal service use, which is what this building tends to attract, and what creates the need for the special permit every time it changes over. And then I think there is some retail sales use that is allowed in the business zones that is not allowed in manufacturing, service establishments. So there's a lot more flexibility with these sort of service, retail, commercial uses between the manufacturing and the business zone, which triggers the special permit.
okay. Thank you. That was helpful. I think I assume we're gonna hold this item, right?
I'm open to
Oh,
all
okay.
considerations. I just want to also
Well-
say that was Miss Katie Wewell who was speaking,
Yeah.
just for people who might not have been able to see you.
Um, y- yeah, so I mean, I want to hear what others have to say, of course. But just on paper, the zone change seems reasonable just to give the petitioners just more flexibility in finding different tenants and different uses for the site. And I just have a question for you, Mr. Stearns. You said facing California Street is the manufacturing use or building. Is that office building there on the corner of the driveway?
It's the mill building, which is used as an office building today, and in which we got a special permit to put My Salon Suites on the first floor.
So that's part of this parcel.
Correct.
Okay, I've driven past it a bunch of times. I just assumed it was a different parcel, different owner, but it's all interconnected, yeah?
That's a 90,000 square foot building, which is very critical to the financial functioning of the property holistically, yes. And it's, we're trying very hard to keep it fully occupied. We have no interest in by manufacturing tenants. And office is one of the uses that is allowed in both business and manufacturing. So we don't need the zone change to fill up the office building. We need the site to be like we did the Pocket Park. We
Okay.
need the site to be attractive to office users.
Yeah, I remember the Pocket Park. You were here a couple of years ago for that. What's in that office building right now? Is it occupied? Do you have tenants or?
Yeah, I mean, Jess can speak to it in detail, but we have a mix of office tenants.
Is
Yes.
it fully occupied?
It's presently not fully occupied, no.
Okay. All right. All right. And again, I just want to be absolutely certain there are no future plans that you foresee or your client foresees for any new development of the site, including the office building and the supermarket and the parking lot.
That is correct. We are not proposing this because of an imminent redevelopment. We've considered development. Any prudent owner would consider development. We've looked at the site. Obviously, the hill makes a huge constraint. I mentioned, the existing leases, the anchor lease with Stop and Shop. They have a lot of control over what goes on at their property, and they have favorable terms, and they like their store the way it is, as we know you do, because you buy your dinner there. So the answer to your question is we have no present intention to develop the property, and that's not the reason for the petitions.
Okay. All right. Well, of course, I want to hear what everyone else has to say. So that's all I have, Chair. Thank you.
Thank you, Counselor Lucas. I'll go to Counselor Roach.
I didn't ask this yesterday because I was not aware, so I'm not sandbagging you. This is V2 of your proposal to eliminate the parking requirements, right? There was another set of proposals, and Ms. Wewell, maybe you can answer this, or Ms. Kemet, that this is not the first. There was a prior set of approaches here, or is this the first? Is this the first that the petitioner has come to the city?
I'll speak to it from our perspective. So we've come to the city 7 or 8 times in the last 20 or 30 years.
No, not on specific things, but on this more general. Not that you came with an official petition, but that there was an earlier proposal about how to accomplish the same thing. Is that true?
I'm not aware. I would kick it over to Ms. Berman, who did a lot of research and preparation for this item, but I'm not aware of any sort of comprehensive look at the parking. Are you, Ms. Berman?
No, the most recent records I could find were for the most recent special permit under 314-22, which was to allow for the reduction in parking, to allow for that the outdoor amenity area. I could not find anything else that was sort of an unofficial discussion or record of an unofficial discussion in my review.
Terrific. Okay, thank you. Obviously, if something comes up, that would be good to know. So I think this is interesting. I think we would generally want to conform the zoning to the use or to any future expectations or desire that the city has. And in no way is manufacturing correct for the present uses, and I don't think we reasonably expect this to be manufacturing. So as a general matter, it strikes me that manufacturing is the wrong zoning and we should find another zoning that's more applicable to the uses or the city's hoped for uses on this land. So that's number one. Number two, it's very clear that parcels of this use which are typically BU are now, by the application of policy, no longer required to have parking minimums. So the combination of those two things strike me that we should be doing something here to get the petitioner the same benefits that every other landowner of a similar parcel would have. So I'm generally in favor of that. And the concerns about other uses are interesting, but that's kind of a risk I think that we have with any large BU parcel, and to not do one, conform it to the present uses, and two, give this petitioner the benefits that every other similar parcel would have based on a fear of what might happen under the right zoning would not be the right outcome here. I understand it, but I think that that's, these are our choices for zoning categories. Thank you.
Thank you. Is there any other member of the Land Use Committee that has a comment or a question? If not, I'm going to bring it in to Councillor Oliver. I see your hand up, and then going with Councillor Susan Albright and Councillor Greenberg. President Oliver, please.
Great, thank you, Chair. I just want to go back and clarify something that I'm 95% sure I've got right. But could planning kind of help me, or maybe it's legal, just confirm for me what I'm hearing then, that this covenant that exists, is the full scope of the covenant limited to parking and the quantity of parking in the Watertown portion of this property? I think that's what I heard, but I want to make sure.
I can go ahead and start, and if Attorney Temple would like to confirm, that's fine. My understanding was that the covenant holds the site to the site plan that was approved in the special permit, and the site plan itself encompasses the entire site. So that would be the parking and the development on site. So any changes to that site plan would require an amendment to the site plan and an amendment to the covenant. So I think it sort of holds the site to the plan itself, but I will defer to Attorney Temple just to confirm that that is correct.
Yep, that's exactly right. It controls and holds the site parking as on the parcel as a whole, including the portions in Watertown and those in Newton.
And that's still, yeah, I think you used the term, belt and suspenders to the special permit itself, right? It's still duplicative in its full scope.
Yes, like I think if I was staffing the land use committee at the time, I would have said it's unnecessary to do the deed restriction.
Well, you could have saved us a lot of time had you been on staff in 88. All right. Okay, so thank you for that. I appreciate that. A couple other quick thoughts. I want to kind of speak to what I believe Councillor Roach was just talking to. Maybe it was never docketed, but last term, somewhere summertime-ish, there was under discussion an alternative, a possibility, right, to kind of, maybe it was just a different approach to resolve the challenge of parking. And it was meant to be, and I think I grabbed this term and I'm using it correctly. It was basically called a special parking permit, or a special permit for parking that allowed for, I've been using the term like a plug and play solution when a restaurant perhaps moved out of one of the bays, right? The commercial locations, and perhaps a gym moved in. And what it would basically say is, and I believe one exists for the street on Route 9, that it basically would say, you don't have to come back to us for a special permit as long as you still have in total the required total number of parking spots. So I believe that was under discussion last year. Clearly that has changed. And now we're kind of dealing with the three items that are in front of us. And I do want to build off of something that Councillor Lucas was just talking about. And I'm kind of curious, like, I understand there are significant differences in use between manufacturing and BU2. but I'm wondering why we chose BU2 here, like versus a BU1. And I don't know what because I keep looking at BU1 and BU2, and there are very few differences. And I'm curious why BU2. Because there's one difference that I'm kind of that jumps out at me, but I'm curious why BU2.
Okay, Ms. Bermo, do you want to handle that question?
In terms of why the petitioner requested the specific district, I think I would refer that back to the petitioner first. I don't want to speak out of turn and assume anything to that regard. So I would first start with the petitioner.
Mr. Stearns?
Yeah, so earlier I said, we were encouraged by the city to seek this. And I should probably be a little more clear. We were encouraged at various times and in various forms by the city's economic development director, by the senior leadership of the planning department in 2025, and anecdotally by members of the land use committee when we were coming in for these interminable special permits and parking waivers, and there was a frustration that this was taking a lot of time for something that really had no impact. So when we met with the planning department and the economic development professional staff last year, and the encouragement was to convert from a manufacturing to a business zone, it was not more, well, we looked at the same use table you're all looking at, and we looked at how we thought we could rent the existing spaces most easily. And the BU2 struck us as having the right amount of permitted uses and flexibility with some, as Councilor Oliver has pointed out, some minor differences between B2 and B1, but we thought B2 would work better.
Okay, I think our Director of Planning would like to say something.
Yeah, thank you, Madam Chair. So I'm, looking at the zoning map, and I think what I initially thought is correct, that business one zones are more commonly found in village center type areas, whereas business two are kind of more, on the perimeter of those. And when looking at this parcel, the closest, so there are other business zones, is business one, but I do that wanted to offer that. And I don't remember there being a comprehensive parking request. I don't know if that was an approach by the petitioner. I know that's the case in some other properties such as the street. I think Piccadilly Square and Union Center has a comprehensive parking waiver. So I just wanted to add that I think business one was envisioned more for the village center type areas.
Thank you, Ms. Wewell. President Oliver, did you want to add something?
Yeah, I'm just that's interesting. Because I will I'll have to refer to a few of the maps as well, but I'll come back to that one. I guess one of the questions that I have a quick follow up there. Ward 1 has a and I'm channeling my my Ward 1 cohorts here. One of the significant areas where there's a difference between BU1 and BU2 is in the allowance of within BU2 vehicle repair shops, major and minor, vehicle sales and service facilities, indoor and outdoor. And I'm kind of a little sensitive to that, but I'll leave it at that. But I appreciate the time, Madam Chair. I've got a few other questions, but I'll let them go for now because I think I've got most of this answered. But I'm kind of curious as to where the rest of the questions are going to go. Thank you.
Okay, thank you. Councilor Albright.
Thank you, Madam Chair. I wasn't here for this item, but since it's come up and I'm here, I can't help but speak about it because it reminds me of a special permit we provided to the building owner in Newton Center to give him more flexibility for when not projects, but when businesses come and go in his building, he was allowed the flexibility to add or subtract or change uses within his building without coming back to the city council for a special permit each time. And this is exactly the same idea. And I can't help but think that this is exactly the kind of thing that we need in Newton, to have the more flexibility to add different kinds of building types so that we can increase our commercial tax base. I'm thrilled with this idea. There's a sea of parking. I've been to this Stop and Shop parking lot so many times, and I've never seen it even halfway full. So there's no problem in parking in this area. And anything that we can do to help the businesses succeed in Newton and provide more opportunities for businesses to come to Newton, it's a great project. And I totally agree with my colleague from Ward 2 that this zoning change seems like a reasonable request. Thank you very much.
Thank you, Councilor Albright. Councilor Greenberg.
Oh, thank you, Acting Chair Leary. I'm in strong support of the rezoning of to BU2 and the repeal of the covenant. This would be in alignment with what many of my fellow colleagues have been strongly advocating for: the preservation and success of our commercial base and the opportunity to attract more businesses to Newton. Right now, we have a barren wasteland of blacktop there. This needs to change, and hopefully this will be the beginning of that change. So I hope the committee votes to approve these two petitions. Thank you.
Thank you, Councilor Greenberg. I'm not seeing any other hands up. I'm just going to weigh in a little bit of myself. I am the Ward 1 councilor as well. This is in my ward. I go here regularly. It's where I go food shopping. It is a sea of parking, 685 parking spaces. But what I think is most important is that I think we all agree we want to support our local businesses. We want to make it a little bit easier for them to make changes. We want them to thrive. We want them to be able to attract tenants. And I think that this request will help with all of that. It's basically, we're matching the use to the zoning. That's what we're doing here. In Ward 1, we have the most zoning mismatch probably in any other part of the city, and we also have the most manufacturing. And where we want to preserve our commercial spaces, I think we need to make it a little bit, facilitate businesses when they come to us and ask for some relief. The covenant should really just be called a big, just a strap of red tape. That's what it is. It's unnecessary. It's duplicative. It's nothing. It's something we really don't need to worry about. We also got a letter from the Charles River Regional Chamber in full support, and they talk about the street. You know, it's a mismatch between the property's current zoning and its actual use. So I also am in strong support of all three items of support of relief. And in fact, it's really only two, because as we mentioned at the beginning, if the first two, the zoning request and the covenant, are approved, then we would NA and the special permit. Well, that's how I stand. And I just wanted to get some sense from the committee, because I do think there were at least a couple who had more questions. And if it's in the committee's interest to hold this item, I will note that we're down 3 members. I'm sorry, Ms. Whewell.
Thank you, Madam Chair. Attorney Temple just raised with me to give the planning board an opportunity to also maybe deliberate.
Oh, yes. Okay. I'll defer to the planning board.
Yeah, if anybody wants on the planning board would like to speak on this, please raise your hand. Oh, Ed?
Thank you, Mr. Chair. I'd just like to make a couple of points. The first is my cheerleader role, and I just want to thank Ms. Berman and Mr. Temple and say, as I have so many times with people who serve us in the city, we are well served by the true professionals in planning and law, and we should appreciate that. The second is that I note we repeatedly talk about the need to facilitate business opportunity throughout the city, and it seems to me that this proposal does precisely that. And when appropriate, I'd like to make a motion to move that the planning board recommend to the city council that it approve the zoning amendment of this parcel to BU2. Thank you.
Thank you. I don't know if we're ready for a motion right now, but has a motion been, what to do with this? Yeah. Yeah. Yeah.
Our phone's ringing now. We're getting.
Chair McCormick, I can speak to that, and Attorney Temple can correct me if I'm wrong. I believe the planning board can make a motion and take a vote if they so choose to recommend the rezoning at this time, or we can, or the board can vote to hold the item to your next regularly scheduled meeting.
Yes, I would prefer to hold. Does that mean now that the motion's been made, we need to vote on that, apparently?
I did not make a motion. I said as appropriate, but one of the things I must say that troubles me is the long drawn out processes. I think this is straightforward, and I'll just leave it at that.
Yes, I agree. I think I would like to hear though from, if I'm sure this is going to go to another meeting here, and I'd like to hear from everybody.
Yeah, just like a team that is dedicated to.
Anyone else from the board would like to hear? Peter?
Introducing them to the right people.
Councilor Maliki, don't you need to vote mute? Okay.
Chair, do you mind if I interrupt for 1 minute?
Please go ahead, Mr. Temple.
Sure. It does appear to sound like that the land use committee may actually vote this out this evening. And if that's the case, then I would recommend that the planning board also vote it out if it's ready to, so that it can all move along on the same path to the full council. So if the planning board prefers to kind of follow the path that the land use committee is taking, maybe the land use committee could first make its determination and vote as to whether it's ready to do that tonight.
Thank you, Mr. Temple. I will note that we are down 3 members this evening on the land use committee.
Madam Chair, we're down 2.
We're down 2.
Yes, Councilor Golden is on the Zoom.
Councilor Golden is here. Okay, I didn't realize he was here.
I am in fact here. Thank you, Madam Chair.
Thank you, Councilor Golden. I'm sorry that I didn't see you, so I'll recognize you, Councilor from Ward 7. Okay. I wasn't clear if Councilor Golden, have you been hearing this whole conversation?
I have.
Okay, great.
I'm sorry, not the entirety, but substantively.
Okay. Okay, so I would like to hear from members of the committee how they're feeling about this. Councilor Block.
Thank you, Chair. It had occurred to me, as it had occurred to Councilor Oliver, to ask about BU1 versus BU2. And when we're talking about zoning changes in this committee, which we don't get very often, it's a small percentage of our work, I always think about what the members of the Zoning and Planning Committee would think about this proposal. I think Councilor Oliver serves on that committee, but we haven't heard from any other members of that committee, and it would be nice if we did. I am personally, I'm actually a little more sympathetic to the special permit petition than I am to the zoning change petition, and I do have a question. Am I am I correct in understanding the special permit petition that it includes removal of the covenant? Is that, I mean, that's the way I'm reading this, is that correct?
I don't believe so, but let me defer to the petitioner.
I think that the 3 items were docketed individually, and that was intentional. I also think that in response to your question earlier about what's the history of this covenant, it was definitely issued by the Board of Aldermen as part of a special permit process at the time in 1988. But I do think it's important that 3 votes be taken, even if the vote on the shared parking special permit is held.
Yes, we will vote each item separately. I haven't yet heard from Counselor Farrell on this item.
Well, could I just ask a follow-up question
Yes,
about
please.
this?
And I'm going to go back to
I
President
just,
Oliver after that too.
the petition for the special permit, 70-26, what I'm reading is that this would reduce the parking requirement by up to 1/3 of what is required and to remove the restrictive covenant on the land. I hear the comments that the restrictive covenant is not necessary. I just wonder if the zoning change is approved, does the restrictive covenant remain superfluous? Or does it have some effect, some rationale, some justification if we did approve the zoning change? In other words, is there any logic to approving the zoning change but not approving the removal of the covenant? And I guess that's to planning and legal.
Yeah, I can take a
Oh.
first stab at that, Chair. From our analysis, we don't see any reason if you're going to rezone it to BU2, it really makes the restrictive covenant obsolete. The restrictive covenant is strictly tied to the special permit and the special permit site plan. And by rezoning the property to BU2, the special permit goes away. So they're really inconsistent with one another. And so I would recommend viewing the rezoning and the release of the restrictive covenant as a package deal.
Well, I appreciate that's what is possible before us, but each is a separate item. And what I'm just trying to drill down a little bit on the special permit petition, 70-26. I'd like to divide that question, Madam Chair. Why don't I just propose that? I think the question should be divided. A special permit that would reduce the parking by up to 1/3. You know, that's the first portion of this question. And then the second is whether to remove the restrictive covenant. And I'm prepared to vote in favor of reduction of the parking by 1/3. I've been to that parking lot. It's very large. Let's just leave it at that. And I'm sure that the petitioner has provided documentation regarding its utilization. I have no reservations about that. And so I'm making that, I guess I don't know if that's a request to divide this. I think I have the right to divide.
Are you asking to divide 70-26
Yes.
into 2 questions?
Into 2 questions, because I understand they're related, but I think they are, I think it's possible to think about them in different ways.
What exactly do you want to, what 2 sentences or paragraphs do you want to divide up?
I want to divide the question regarding the reduction of the parking by 1/3 from the removal of the covenant. And I would like to have the opportunity to vote separately on those 2 aspects of this petition.
So I see that it's in the request for the special permit and to allow for shared parking at 148 California Street.
Mm-hmm.
it talks about the 1/3 reduction in parking to 260 stalls
Mhm.
and allowing for more flexibility for future tenant. And it doesn't say anything about the covenant in that.
Okay, well, I'm looking at,
My question, what I was wondering about, if we approve 7226, the petition seeking release from the restrictive covenant and the special permit. What would that look like, Attorney Temple?
Yeah, I guess I'm struggling to follow you, Counselor Block. There are already separate docket items. So if the idea is you to vote on the special permit separate from the request to rezone and separate from the request to release the covenant, you can do that. There is already a standalone docket item just for the special permit relief. But again, I would hold that. I would save that until after you've made a determination and a recommendation on the rezoning and on the deed restriction, because the special permit relief is really in the alternative.
Councillor Block, did that make some sense to you or
I-
help you to understand it better?
sure, I'm willing to put that off. That's how I was first initially thinking about what was before us, that we and the entire city council should decide whether to change the zoning and change the covenant. And if that happens, then the special permit is superfluous. But based on what's in front of me tonight, I would vote in favor of a petition to reduce the parking, but I would not do so for the zoning change or the covenant change. I would like to hear more about that, especially from members of the Zoning and Planning Committee. Thank you.
I'm going to go to Councillor Roach.
So I think there's a reason why it can't be separated, and it's this. The number of parking spaces under the special permit are fixed, not only in number, but in their place and size by the site plan. And so the restrictive covenant is the site plan and the special permit is the number. If we were to separate out the questions, I believe we would probably have to pick and choose which spaces on the site plan were being removed from the total count. So I think I understand Councillor Block's approach here, which would be they are, as Mr. Temple said, in the alternative. Councillor Block, I'm understanding, is saying the lesser relief is also the easier to grant, and the larger relief, which is the zoning change, merits some more discussion. And therefore, if we went in the other direction, we could give the lesser relief and not do the zoning change immediately. By the way, I'm not necessarily in favor of that, but I understand the argument for it. But I think that we can't separate out the reduction and the covenant, because we're going to have to, the covenant is tied to the site plan. Does that make sense?
I'm not sure I totally follow that. My understanding is we can vote each one as we choose.
No, I understand, but Councillor Block was suggesting separating out the two clauses of 70-26.
Yeah, I don't, yeah.
And I don't think
we
that can
do
be, I don't think that can be done.
I don't think we can do that. Councillor Farrell, do you want to, I'm interested in your thoughts about this.
Thank you, Chair. I appreciate your
You
curiosity.
can tell me the buzz.
I too am interested in my thoughts about this. And I'm listening intently to each of my colleagues. And in this particular arena, I was initially predisposed to agreeing with these requests, but I'm learning a lot. And I would like to continue to listen. I also would like to continue to understand why, Mr. McCormick, you had a feeling that you wanted this to go to be held. Did I misunderstand that?
I just wanted to wait till I heard what, if the board would, if this council is going to continue it, I would just as soon continue it, that's all.
But you personally are prepared to make a decision on this tonight regardless of what the council does? Is that?
No, I wasn't, that's what I wasn't, I am personally would be in favor of this, I'm
Okay.
definitely in favor
Okay.
of changing this from manufacturing to a
Okay.
BU2 code, that definitely, and I think that is our only thing, I don't think we have a voice on what
Yeah,
happened with
I
the
appreciate
covenant.
that, but I just was curious about your
Yeah.
thought about that. But Chair, what I'm really interested in hearing now is Chair Oliver's continuing questions. I really was fascinated by the choice between BU1 and BU2. And
Can you speak into the microphone a little bit more?
I'm sorry, Chair, yes. I'm interested in hearing what Councilor Oliver will continue to say because I appreciate his deep involvement in these issues. And I would just like to hear more.
Okay.
I'm not sitting here.
I'm just, it's getting to be 8:30.
Yep. I'll
We
make
have
a decision when.
other things to talk about.
Yeah,
And I want to hear from every member of the committee that's here right now.
thank you. You'll hear from me when the rest of the questions are answered. Thank you.
Councillor Lucas.
Thank you. I move that we approve items 71-26 and 72-26. That's the zone change and the petition seeking release from the restrictive covenant. Thank you.
Okay, we're going to hold that because I'm hearing from other people yet. Still, sorry. Councillor Golden, if you want to weigh in, you're welcome to. Right now, I'm going to go to back to Councillor Oliver and then to Councillor Albright, who both had their hands up.
Great, thank you again for indulging. So what I heard a minute ago about BU1, BU2, I do want to go back to that because really, if we're looking to be consistent in zone, then and I think that that's a general kind of a premise, right? Not trying to have too many all over the place and spot zoning becomes a question, and I don't want to go there because that's not what I'm proposing we're doing here. So forget I said that S zoning word. Apologies to Mr. Temple for even thinking it. But what I heard from planning a minute ago leads me to believe then that it was kind of a BU1, BU2, it's almost identical. So I have two things that I would like to ask land use to consider before you vote this out. And one of them should go to the petitioner. And that is, as opposed to changing zone from BU2, change it to BU1. Why? Because California Street has an entire length of 1, 2, 3, 4 blocks of BU1. There is no BU2 in that area until you get all the way up to, I think it's Bridge, yeah, Bridge in California. And then there's one tiny little lot that's BU2, which is interesting to me, but that's an aside. And I'm going to pile on one other request, and I apologize for this, but I would like to see a comparison of the differences between BU1 and BU2 in terms of the uses. Again, there are very few of these. I know that I have a printed copy, this is what happens to your life when you become a counselor. I have a printed binder here of chapter 30 on my desk. It's probably a little out of date by now, but I would like to, I want to understand ideally, before you vote this out, Madam Chair, the difference between BU1 and BU2. I think there's a solid case for BU1. And here, in the absence of a strong argument for BU2, which I haven't heard here tonight, BU1 makes more sense to me if we're going to modify the zoning here.
Okay, President Oliver, I think I
yeah.
understand that. I'm going to go back. We did have that discussion between BU1 and BU2, and we'll go over it one more time. I know the petitioner would like to make a comment on that, and I'd like our Director of Planning to make a comment on that as well. So we're all clear. There is already a motion on the table. So let's get to that.
Yeah, please, because I haven't had that conversation yet, Chair.
No, we had a discussion.
We're
Well,
having it right now.
Yes.
Thank you.
We did have it before too. And then I'll come back to Councilor Albright.
I'll be very brief. It would be exceedingly frustrating to us if we ended up with the rezoning to BU1 instead of BU2 by just giving you two discrete examples. If we want to have a veterinary hospital, we'd have to get a special permit. The difference between not being allowed and special permit. If we wanted to have an indoor place of amusement, which is like a bouncy house, a place for children's birthday parties, in the BU1, not allowed. In the BU2, allowed by special permit. So the idea that we might be going backwards, so to speak, if the first tenant we get, if one of our existing tenant moves out, is a children's play type use, it would be really frustrating to have the more restrictive uses after all the effort we've gone to encourage the kind of uses we're bringing. So that's an example.
But both of those would only be available to you in BU2 under a special permit, correct?
It would still be a process, but having it be available by special permit is a hell of a lot better than having it be prohibited.
Okay.
Veterinary hospital, indoor place of amusement. Just two quick examples. I could probably give you more.
And separately then, I'd like to ask planning if we could get and again, maybe this printed copy of the tables is accurate, but I do recall we've been making some changes to these over the past term or so. I would like to just get maybe just a rundown of or an updated version of the tables 4.4.1, please. And yeah, all 3 pages are 4.4.1. I would appreciate it.
Okay, I see Ms. Kemet's hand is up. Are you up for that specific reason, Ms. Kemet?
Yes, thank you, Madam Chair. I could pull up the use table right now if folks want to do that. It's in the ordinance.
Thank you. Yes, go ahead.
Do you happen to know if that one was updated after this past term? Or
We-
verified that nothing changed?
We update it regularly. I believe the version that's available online was last updated in December, maybe more recent than that.
Yeah, I can speak to that. It was last updated on December 1st, 2025.
Great, thank you.
If I could, Madam Chair, sorry, this is Katie Wewell. I did want to offer, I don't have a full sort of analysis of BU1 versus BU2, but I do know in past discussions about where to allow certain uses, Business 1 was described as sort of more prevalent in the village center zone. So you can, see it in Newtonville, West Newton, Newton Center, kind of that's sort of the pattern of the zoning, specifically in the village centers. I'm not sure that this area, constitutes a village center. So I do see the argument for Business 2, which is also just more permissive, albeit by special permit, for some of those uses that are not allowed in Business 1, but are contemplated by special permit in Business 2. But I'm happy to kick it over to Ms. Kemet to bring up the use table to take a look at that. But I think Attorney Stearns pointed out some of those examples.
President Oliver, would you like to hear the use table?
Yeah, I don't know about here, but seeing it might be. And by the way, are you going to show something that's currently on the site? Because I can just go look real quickly and I'll raise my hand again if there's something kerfuffle here.
Yes, this is available online. I can send you a link right now if you wanted to just pull it up.
Sure, that'd be great. Thank you.
Sure.
And again, like just talking to Ms. Wewell's comment, I'm not arguing BU1, BU2 in a village center, which is more or differently appropriate. All I'm looking at is California Street. It's BU1. I look at Watertown and Adams Street in the closest village center, right, on Anthem, and it is a mixture of BU1 and BU2. So I get the point. There's just no BU2 close up to this particular property. And I thought I had heard earlier that kind of consistency is appropriate.
Yes, I
but
would say
anyway,
there's no other
thank you.
giant plazas on that street either, with
No
office
argument.
buildings and supermarkets and a number of retail businesses.
Thank you for the argument.
I'd like to recognize Councillor Albright.
Thank you, Madam Chair. As Councillor Block was looking for folks who are members of the Zoning and Planning Committee, and having been a member of that committee for 10 years and chaired it for 2, I would be happy to give you my impressions. Obviously, I can't represent the committee. It's not a manufacturing district and probably will never be a manufacturing district. So yes, it obviously should be rezoned as a business district. And if you're looking for an opinion of BU2 versus BU1, it should be BU2. This is a huge plaza with lots of parking. It's an opportunity for Newton to have more tax base. It should be a BU2. So that's a representative of the Zoning and Planning Committee opinion. Thank you.
Thank you very much, Councillor Albright. Councillor
It's
Donovan.
just another opinion from somebody from zoning and planning.
Yes, it is.
Yes, I said I can't represent the committee.
Councillor Damabed, please go ahead.
Thank you, Madam Chair. Similarly, as Councillor Block was looking for thoughts from the members of ZAP, and I happen to be here, I thought I would associate myself with Councillor Albright's comments and just say that it also makes sense to me to be bringing the zoning into alignment with the use. We had a similar conversation about alignment of zoning and use in ZAP last night, albeit not about this parcel in particular, but more broadly, and the idea that we can help to facilitate, greater flexibility and usability for the parcel by local businesses seems like the right kind of utilization of zoning to enable growth and revenue. So thank you.
Thank you very much, Councillor. Councillor Greenberg.
Oh, thank you, Chair. I'm just really befuddled here. This is the same committee that denied a project because it was a commercially zoned project and it was having residential built on it. And here we have an opportunity to encourage more commercial, help our commercial base, and we're arguing about little minutia things that doesn't help our commercial base. So I'm just really, really confused about the inconsistency and our decision making. And if we want to help our businesses, we should make those decisions. Thank you.
Councillor Greenberg. There is a motion before us. Before we go to that, is there any other member of the committee that would like to comment?
Madam Chair, I'd just like to say my inclination and still my desire is to grant the relief requested. However, having said that, I think that the council president's desire to see a clear comparison of what we're ruling in and are ruling out with BU1 versus BU2 is completely reasonable. I'd like to see what that looks like. I appreciate plaintiff citing a few instances. Just like to know, are there what's, it's a subjective call, but are there some noxious uses that are being ruled in or ruled out? I just don't know.
So perhaps we could bring up the use category, which Ms. Kemet had already said she would go over, and a link was sent to President Oliver. So please, let's bring that up, and maybe you could share your screen.
Thank you.
Ms. Kemet, thank you.
Sure. Yes, just give me one moment. So I'm pulling up section 4.4.1. This is in the zoning ordinance, which is available online. So we'd be looking here at BU1 and BU2. A lot of similarities in what's allowed by right and by special permit. If there are any specific questions.
Could you go back to the top for a
Sure.
minute? So,
Sure.
so we can make sure that we're seeing the first two columns. The first one is BU1 and the second one is BU2. So those are the two columns that people should be looking at. So
That's
now when you scroll down, people will know what they want to look at, because otherwise it can be confusing. Okay, thank you.
That's right. And here towards the right, that's manufacturing. So that is the current zoning for the parcel, just to compare.
Yeah. Could you go through and read each one out, please?
Sure. From the top?
One moment, please. Councillor Block.
Yeah, just read off where there's a difference between 1 and 2. We don't need, if they're identical, then it doesn't matter.
Okay.
And additionally, by category, the residential uses are not different, and the civic institutional uses are not different. We can streamline this
Okay.
even by
Sure.
category.
Good suggestions. Because we want to get through this.
Sure. The residential uses are the same in BU1 and BU2. They are the same in civic and institutional uses as well. So that includes things like libraries, religious institutions, and schools. Those are all the same. For commercial uses, at the top here, adult daycare, animal surface, those are the same. For most of these, I believe it's the same. I don't have this memorized, so I'll, if you bear with me, there's a difference here in fuel establishment, which I believe was mentioned earlier, where it is not allowed at all in BU1. It is allowed in BU2, but only by special permit.
Like a gas station.
Yes.
Okay.
There's another difference here in office of a contractor, builder, electrician, or plumber, or similar enterprise, not allowed in BU1, allowed under certain circumstances in BU2. For outdoor storage, not allowed in BU1, allowed by special permit in BU2. Most of these are the same. There is a difference as well in vehicle repair shop, vehicle sales, and veterinary hospital, where they're not allowed in BU1. They are allowed by special permit in BU2. Industrial uses are the same, with the exception of wholesale business or storage facility, where they are not allowed in BU1. They are allowed under certain circumstances in BU2. Open space uses are the same. Restricted uses, there are a few differences here. Medical marijuana treatment centers are allowed by special permit in BU2. They are not allowed at all in BU1. Similar situation for marijuana retailer, firearm business, firing range, gunsmith, not allowed at all in BU1, allowed in some circumstances, allowed by special permit in BU2. So
Thank you very much, Ms. Kemen. That
Sure.
was very helpful. Councillor, President Oliver, please, I see your hand is up.
Yep, sorry. So thank you for doing that. It turns out the book that I printed a ways back is actually accurate. And Councillor Roach did bring up the only difference in residential use between BU1 and BU2 is in BU2, the number of stories is capped at 4 by special permit. BU1 is capped at 3 stories by special permit, but they're both special permit. I also want to just kind of make sure that people on this call, including the petitioners, understand I am not at all trying to make a decision between supporting the plug and play, my term, business opportunities or not. To me, I want to be really clear here. this is a question about utilizing BU1 or BU2. I still personally think that BU1 is the right way to go, but I'm going to be supportive of BU2 because I believe that that's the right thing to do for your business, right? For your property. I would have a hard time seeing CVS being converted to a bouncy house facility, but I get the point. And in all reality, I still believe that the cleanest solution of all would have been sticking with, and I think I heard our director of planning, director of planning mention the right term, which is the comprehensive parking permit that exists in a couple of other locations in the city. But I get the point. I appreciate the indulgence here, if not the arguments. Thank you for indulging the exploration here. I think we're getting this one right. Again, I still prefer BU1 for the reasons I've stated. But if we're going to be pushing forward with BU2, again, I'm just one opinion here. But I'm glad we've had the conversation. So I appreciate the indulgence.
Thank you very much for your comments, President Oliver. I think that was an important exercise to go through. I don't see one. Yes, Councillor Roach.
I second the motion.
Okay, there's a motion on the table now, and this is for approval. I got the wrong thing. Of 71-26. This is the rezoning change. And 72-26, the petition to seek release from the restrictive covenant. Yes, Councillor Lucas.
Thank you. I move to close the public hearing and move approval for 71-26 and 72-26.
Okay, motion is made to close the public hearing. All in favor?
Aye.
Aye. Any abstentions? Any nays? Okay, that's planning board.
Yes, can I entertain a motion to close the public hearing?
So moved.
All in favor, say aye.
Aye.
Any opposed? Any abstentions? Thank you, Madam Chair.
You're very welcome. So as I said, I'd like to vote on these two items separately. And then we still have the third item to consider, and there's no motion regarding the third item. Is there any? Yes, Councillor Lucas.
I move that, well,
You move it.
I move that we hold 70-26.
Okay. Councillor Roche, did you have your hand up? Or
I was simply going to request that we wait to make a motion on that until we resolve the earlier two, but I think we're fine.
okay, thank you very much.
Shouldn't the planning board have its own vote on the first item before everyone moves on to these other issues?
Chair, I would recommend that the clerk can first call the roll for the three motions for the land use committee, and then the planning board can go, because I don't think there's been any votes yet.
Okay, so we're going to vote on each one of those items separately. Okay. So, yeah, Councillor Lucas.
Is there anything that planning needs to show? Because normally we see a
the
council order.
Board order, you're right.
Yeah, I don't know if they have anything ready tonight, but I'll leave that to them.
I can chime in on that, Chair. We have no orders to show. The rezoning order and the release of the covenant order are just going to be straightforward forms. They'll be in the Friday packet before the next council meeting.
Okay, but thank you for that clarification. Okay, so I'll ask the clerk to call the roll on the first item, 71-26.
Councillor Block,
Abstain.
Councillor Farrell,
Aye.
Councillor Golden,
Aye.
Councillor Irish, Councillor Kelly, Councillor Leary,
aye.
Councillor Lucas,
Aye.
Councillor Roach.
Aye.
The motion passes with 5 yeas, 1 abstention, and 2 absent.
Great, thank you very much. So the second motion, 7226, regarding the restrictive covenant, please call the roll.
Counselor Block,
Aye.
Counselor Farrell,
Aye.
Counselor Golden,
Aye.
Counselor Irish, Counselor Kelly, Counselor Leary,
Aye.
Counselor Lucas,
Aye.
and Counselor Roach.
Aye.
The motion passes with 6 yeas and 2 absent.
Thank you very much. The third one, 7026, there is a motion to hold. Are there any comments on the motion? Seeing none?
No, I did actually. I was
Okay.
messing with my button. I apologize.
okay.
I'm not used to it. Does it make sense to, I know that they're in the alternative, Mr. Temple, but does it make sense to maybe have a vote on the merits? And then, you know what, withdraw it. Let's hold
Yeah,
it.
I understand what you're saying, Counselor, and you could in theory. I think the cleanest path is just to hold it so that it can be withdrawn ultimately.
I withdraw my comments.
Okay, thank you. Okay, so let's call the roll on 70-26.
Counselor Block,
Aye.
Counselor Farrell, Counselor Golden,
Counselor Golden?
I think he's frozen.
Oh. Okay, maybe we can get back to him.
Counselor Irish, Counselor Kelly, Counselor Leary,
Aye.
Counselor Lucas,
Aye.
Counselor Roach,
Aye.
Counselor Golden.
Aye.
The motion passes. The motion to hold passes 6-0 with 2 absent.
Okay. Thank you very much. We're on to our next item.
No,
I'm sorry. Recognize the planning board. Not used to this, sorry.
Yes, I would be in favor. I'd like to entertain a motion to, which it's just the first item on approving 7126 on rezoning to BU2. Could I have a motion? Okay, all in favor? Let me just see if everybody's in favor of this, and then we can go around. All in favor, say aye.
Aye.
Any opposed? Any abstentions? One abstention. Thank you. Thank you, Madam Chair.
Welcome. And thank you to the petitioner.
Thank you very much.
We're going to move on to our next items. So the next item is 69-26. This is requests to allow a home business in a detached accessory building and to allow the business to exceed 30% of the ground floor area. And I'm going to ask the planning department to go first.
Thank you, Madam Chair. I'm going to go ahead and share my screen. Just bear with me as I pull it up. All right. So good evening, everyone. Again, Sandra Berman, Senior Planner for the City of Newton. I will be presenting the planning presentation for petition 69-26 for 224 Melrose Street, which is a request for special permit site plan approval to allow a home business in a detached accessory building and to allow said business to exceed 30% of the ground floor area, and parking relief to allow more than 2 parking stalls in the side setback. You'll see here from the aerial map that the subject property at 224 Melrose consists of a 15,750 square foot lot. It's improved with a single family residence constructed in 1863 and has an existing detached 1-story garage. The site includes topographical changes, particularly towards the middle and rear of the lot, where the elevation slopes downward towards the rear lot line eastward for an average elevation change of approximately 10 feet. The subject property is located in a single residence 3 district zone in the Auburndale neighborhood just north of Commonwealth Avenue. The surrounding neighborhood is zoned SR3 and it largely consists of single and 2-family residential uses. Further south, across Commonwealth Avenue is a mixed zoning area of multi-residence 1 and 2 and Village Center 2 districts with higher density residential and commercial uses. You see here again the requested zoning relief to allow a home business in a detached accessory building, to allow a home business to exceed the 30% of the ground floor area of the primary dwelling, and to allow more than 2 parking stalls in the side setback. Criteria to consider, we have the standard for special permit criteria plus additional criteria for parking relief, that the site is an appropriate location to allow for the proposed accessory building as designed, that the proposed accessory building does not adversely affect the neighborhood, that the accessory building will not be a nuisance or serious hazard to vehicles or pedestrians as designed, and that access to the streets is appropriate for the types and numbers of vehicles involved. And finally, that literal compliance with the parking requirements is impracticable due to the nature of the use, location, size, width, depth, or shape or grade of the lot, or that such exceptions would be in the public interest, or the interest of safety, or the protection of environmental features. Planning notes that the proposed accessory building will allow for a modest housing increase of 1 unit and the creation of an ADU above the ground floor home business without exceeding the allowable FAR, open space, lot coverage, or proposing extensive increases in paving. The extension of the existing driveway allows for all 5 required parking stalls to remain on site, with 4 arranged in a tandem configuration. The configuration allows the petitioner to meet the parking requirements without the installation of a new curb cut, driveway, or excessive expansion of paving to the site, proposing instead a smaller 2.1% increase in impervious surface driveway area from what is existing. Planning also notes that the proposed retaining walls at the rear of the accessory building are just under 4 feet in height and recommends that the petitioner be aware that any increase in height will likely trigger relief. Although the proposed accessory building is larger in square footage, stories, and height from what is existing, the height and stories are allowed by right, and the increase in square footage on site does not require FAR relief. And finally, the relocation of the accessory building will bring the structure into compliance with the primary dwelling's dimensional setbacks, as well as increase the distance of the accessory building from a residential abutter to the north. That concludes the planning presentation. I will go ahead and stop sharing my screen.
Thank you very much, Ms. Berman. Let's hear from the petitioner on this item. Yeah, you really have to get it close to your mouth in order for everyone on Zoom to hear it.
Good evening, Madam Chair, and thank you for the opportunity to present our project and request for a special permit. My name is Naomi Bass Grace, and this is my husband, Ben Grace. I grew up in Newton Center, and we have lived in our current house at 224 Melrose Street in Auburndale for the past 15 years with our 3 children. We are extremely fond of our neighborhood, and over the past 15 years, we have developed strong supportive relationships with our neighbors, several of whom have submitted emails to the Land Use Committee in support of our current proposal. Our project includes replacing our existing 1-story detached garage, which is not historic and is in need of replacement, with a 2-story detached accessory building that conforms to the style of our primary dwelling. The new detached building will consist of a 1st-floor chiropractic office for my husband, Ben, and the 2nd story will be an accessory dwelling unit. Ben has operated his chiropractic practice in Newtonville for 20 years as a sole proprietor without any employees, and he intends to maintain that same low-volume, neighborhood-compatible practice in the proposed detached accessory dwelling. It is significant to note, as the planning department mentioned, that the height and stories of the proposed accessory building are allowed by right. In addition, the relocation of the proposed structure will bring it into compliance with the primary dimensional setback requirements, in fact, increasing the distance between the accessory building and the abutting property. We are seeking zoning relief in 3 respects: to construct a detached accessory building with a home office on the 1st floor and an ADU on the 2nd floor, to allow the home business to exceed 30% of the ground floor area of the dwelling, and to allow more than 2 parking stalls within the side setback. I do want to mention that with respect to the parking arrangement, while we will have space in our driveway for 5 parking stalls, 4 of which will be tandem, my husband Ben only sees 1 patient at a time, and he can easily schedule patients so that there is no overlap. So we do not anticipate ever needing to have all 4 cars in tandem. We are enthusiastic about this project because it will enable Ben to convert his longstanding existing practice into a home business and create an additional housing unit. And we feel confident that the proposed use is consistent with the character of our neighborhood. we respectfully ask that you approve our request for a special permit. Thank you.
Thank you very much for your presentation. Do you happen to have any maps with you, or that shows the what exactly what you're doing? I think the committee would like to see that. And yeah. Okay, can you point out where the parking spaces are?
So they're denoted in green to the right of the screen.
Yeah, you do have to speak into the mic to make sure
Yep,
everybody.
thank you. They're denoted in green to the right, where it says proposed ADU, and they're 9 by 19 and they're numbered.
Okay, thank you. Thank you very much.
Point of order.
Yes.
Can you just use your mouse and show us where it is?
Oh,
Oh,
certainly.
Yeah.
Yeah. So we've got 2 here. These are side by side, and then we have 3 in tandem. So these are the parking areas.
Why don't we be complete and just also you can just point out where where the new home
Oh,
business and the
certainly.
ADU are, and
Yep, so-
how far they are from the abutter.
Okay, so we have 7.5-foot setback here on the side. And this is the structure here, 20 by 30 roughly.
Okay, and I noticed that the existing one-story garage is right on the line. Is that correct?
Correct.
Correct.
Okay. So if you could, we might have questions, so they might want to see the map again, but we're just going to go and, I'm going to first open the public hearing. And then we'll take it into committee. So planning's gone. Yeah, they didn't stay for this one. So is there any member of the public that would like to speak on this item? Yes, please come up. Okay, we just your name and address, please. And please speak into the mic so everybody can hear you online.
Hopefully loud and clear. All right, good.
Yep.
Well, thank you for allowing me to speak. My name is Andrew Marchand. I am also grew up in Newton, graduated from Newton North High School along with my wife. We have just purchased a property. We are the family that is on the northern abutting line where the proposed project is. And so obviously for us, this is the most direct impact of a project. And I guess what I would, I'm just an ordinary person with a week to prepare, so I don't really have a lot of diligence involved with rights for myself and the rights of the proposed plan. But what I do want to share is just a little background and my concerns. So my wife grew up in Auburndale. We love Auburndale. We love Melrose Street. Like, it has historic charm. It's a family neighborhood. Kids and families going to the Cove, Lions Field. I grew up playing baseball there. Having close proximity to Northampton Village, it's really a great place. Just a real neighborhood feel. So I agree with Naomi and Ben, who are also, we've just newly introduced to them, obviously only 6 months in, but they have a family. We have a family. I also have 3 kids, all in school as well. Really, as I think about this, and probably anybody from my perspective, that, an ADU has a residential concept. And so, like, if that goes in, there is a neighborly thing. So there would be a long-term tenant, and that is, part of a neighborhood. Where I have concern is like the nature of the use And where it is in proximity to my property is a little displacement from the character of the residential expectation I would have, purchasing a home here where I have, it is going to be hard for me to understand what volume means in a practice, but this is a medical practice and this is going to have, frequency, visitors, strangers directly in sight and in view. And really where the raised garage where it is currently actually does provide privacy actually, but moving it to the east, it opens up where the practice will have people that I don't know parking. And so with side by side to where my patio is, where I spend my time, where, we expect to enjoy our property, the use of it is recurring. It'll bring noise, it'll bring people talking, it'll bring right into my backyard. So I that is my primary concern. Of course, understand, but the secondary thing is the parking. So I think the proposal has an extension of the driveway, so I'm not entirely clear as to what that means. So one, is going to go easterly. Two, does it go northerly? And northerly, I think, brings it right onto my property line. And, tandem parking, if you have a residential unit, one, their family, then two, somebody residing, and then three, a business, that's a lot of cars. And the cars are going to go, tandem parking is annoying. And so cars are going to go on the street. And people parking in front of my property and likely others, at my expectation, things I can't control, concern of mine.
Okay. Thank you very much for your comments.
Okay, do I have time for?
Well, you have 3 minutes and you've gone over by a minute, but I don't think there's many people speaking. So if you would like to wrap up, please go ahead.
Well, I just, I think my request would be, this is very impactful on me and just, and really on a residential area to me and potentially other people like me, where this could become a precedent that I would like some time to do my own diligence and respond to this. So I think that would be my request, yeah.
Okay, we're going to thank you for those comments. So we'll take it into committee and have some discussion.
Madam Chair, I'd like to speak to him as a member of the public. This happens to be my chiropractor, so I'm not speaking as a city councilor.
Okay, I've never heard of that before, never seen that before, Councillor Albright, but you're speaking as a member of the public.
Yes, I remember Ted Hesmahan did this a couple of times.
Hold on one second, point of order.
Point of information?
Yes.
Does this mean that Councillor Albright will not be speaking subsequently as a councillor on this item? And that you'll only
The question, Councillor Albright, is, are you only speaking as a member of the public and you won't be speaking as a member of the council?
I think that's fair, and I'm happy to speak only as a member of the public.
Point of order?
One more point of order, Councillor Lucas.
I guess through the chair to Councilor Albright, does this mean that you're going to recuse yourself when this comes to a vote on the full council?
No, I have no need to recuse myself. I have no financial interest in this project.
Can we get Mr. Temple's interpretation of this, please?
Certainly, Mr. Temple.
Councilor Albright, if you're not going to recuse yourself, then just speak as a city councilor. You can't act on the matter as a city councilor, but speak on it as a member of the public. I don't think there's really, unless you ever need to recuse yourself, just speak as a councilor when it's the appropriate time.
Oh, okay, that's fine. Madam Chair, I'll speak as a member of the city council when the time comes.
Thank you very much. Thank you, Mr. Temple, for that clarification. That was very helpful. So let's go into committee. I see Councillor Lucas's hand up.
Thank you, Chair. I got some questions on this proposal, so if I could ask the petitioners to step up to the podium, please. Thank you. I'm looking at the site plan right now, And it says that there is going to be a wooden fence along the left side of the property. Is that there right now, or is that what you are going to install?
That's there right now.
Okay. And that wooden fence goes for the entire length of the property, is that correct?
Yes, sir.
So it's there right now, okay. I'm just speaking to that simply because I believe the gentleman who spoke previously lives on the other side of the fence.
Correct.
So there is some separation between properties. Okay,
Absolutely.
and how high is that fence?
Oh, I would say
Approximately.
No more than 4 feet.
4 feet, possibly.
So it's not taller than the average adult.
Correct.
Okay, good. So, generally, I have one more question on the site plan. Can you just bring up the site plan again on your screen and so everyone can see what we're looking at, please?
Right, 1 second.
Madam Chair, this is Kat from planning. We can also pull up the site plan if the petitioner is,
If you're having trouble, the planning department can pull up where's a millennial when you need one, right? Go ahead, Ms. Kemet.
all right, one moment.
Okay, thank you, Ms. Kemet. So can you just zoom in on the right to the proposed site plan? I just want to go over the parking again. I understand you said that the stalls are 9 by 19, which is conforming, which is great. It looks like stalls 1 and 4 are all in a straight line, and stall 5 is a little off on the right. If cars are parked in 1, 2, 3, and 4, can a car parked in 5 exit the site without cars in stalls 1 through 4
Yes.
moving? Yes?
And the one there, no, they can't get.
I don't see how that's
I
possible.
just want to be clear
It's
what
a
we're.
tandem.
No, it's tandem. But our point was that Ben only sees one patient at a time. So one of those cars will be Ben's car, one will be a patient's car, and he will schedule patients so that there is no overlap. So there will truly only be.
And I will schedule a buffer between patients, allowing for one patient to leave before the next patient comes in.
Okay.
And I only see one patient at a time.
Yeah, I got that. Okay, so again, if someone's parked in all of 1 through 4 and someone's parked in 5, the person parked in stall 5 will have to wait for everyone in 1 through 4 to move, right?
Yes.
Okay, all right. Just want to be clear. And you live at this house, right?
Yes.
And how many cars do you each own?
We have 2 cars, but I work out of the house, so my car is not there during Ben's business hours.
Okay. And you see patients Monday through Friday?
No, 4 days a week currently.
Oh, okay. All right. Same concept. All right. Okay. All right. And all right. Okay. So that was it then, I guess, with that. And there's going to be an ADU.
Yes.
And if someone who lives in there owns a car, where are they going to park?
So there's the zoning requirement. There are no zoning requirements for an ADU as far as parking. ADUs do not need parking.
I understand,
Uh,
but
it- Yeah, just living close to the commuter rail, we would just rent to people who probably didn't have a car.
so you would only rent to someone who doesn't own a car?
Possibly.
Oh, well, I think that's beyond the, well, um, I don't know what to say to that.
I mean,
It's your prerogative, but,
It, it may be a family member who's no longer driving. We don't know yet who that
okay,
person might be.
As,
all right.
as someone who has a tandem driveway, I understand this situation, but I will want to remind you that there is no relief needed for the parking. They're putting in 5 stalls, and it sounds like you don't even need 5 stalls.
Correct.
No, it's not
Uh,
that, I understand that there's no requirement. I'm just saying, if you rent to someone who does not own a car and they decide 2 weeks later, I want to purchase a car and park it on site,
We would
that's what
say
I'm,
no.
you would say,
No.
you would say no to them, you cannot park the car on site?
I mean, that would be a part of the lease.
Oh, okay, well, I'm not gonna, that's beyond this committee, so I just want to understand the whole situation here, okay? So I'm supportive of the ADU, just so you know. I'm supportive of the home business as well. Just trying to get a better understanding of the site and what is gonna happen and what could happen, but you're saying you wouldn't even lease to someone who owns a car, and you would put it in the lease that you cannot park a car on site.
Yes.
Okay.
Of course, that's not something that we.
Oh, yeah.
voted
That's
for.
not something, yeah. And I have a question for Mr. Temple. I think I know the answer. Are we allowed to condition his appointments that they be separated by a certain length of time? You're muted.
Say that again, Counselor?
Are we allowed to put in a condition into the council order that we can request that the petitioner only schedule patients within an hour at a time, or whatever they feel comfortable with? Is that something that we can do?
It's not something we've typically done with home businesses. Home businesses are allowed by right. I wouldn't recommend going into that level of control. I cannot think of an instance where it's ever been done before. There are certain controls as to the intensity of the use already in the zoning ordinance, so I would recommend sticking with that.
Okay, thank you. And again, I just want to go over the home business again. It's a medical office and you're a primary care physician?
I'm a chiropractor.
Oh, I'm sorry. Yep.
Yep.
Council, yep. My apologies. Okay, thank you. That's all I have for now. Thank you, Chair.
Okay, thank you. Is there any other member of the Land Use Committee that would like to? I saw Councilor Roach. Well, let me go to Councilor Block. It is your ward.
It is my ward, and I know Melrose Street very well. It's a beautiful street.
It is a beautiful street. I walked down it today.
You have a beautiful house.
Yeah.
Your neighbors have twin beautiful houses. Yeah, really very special. And I want to say I support the concept of an ADU. I support the concept of a home office. I have to come back to the parking, which Councilor Lucas was focusing on. It isn't just your intentions. You realize that when we approve this and you sell this property at some point and somebody else is there, that they will have the same benefit of what we approve tonight. So they may or may not use all 5 parking spaces for whatever reason, whatever combination of needs they have. And I've never seen a parking plan like this. I haven't been a counselor a really long time, but last session, 4 tandem spaces in a row, I don't think it appeared because it's such a cumbersome way to park vehicles. So I can tell by your reaction that you have clearly thought about this. So what's your comment? What was your thought process regarding how to at least position parking that you shown us?
I think just what I've already said, as far as staggering the appointment times. So as one person leaves, another person would enter.
Hmm. Okay, and as I said, someone else could move into the house and not do that, or not maybe financially be able to do that. They might need to schedule. I mean, typically, the next patient is there to take
mean,
over after a 5-minute break or a 10-minute break, or, what do you?
I mean, I'm sorry, I'm planning on practicing for quite a while.
Well, I asked this question just so that you know what we're sort of mandated to do. We have to think
Alright.
about these things a little longer term than just you.
I guess the other point I would add is just, Ben has his own philosophy about the relationships he builds with patients. He is not rushing people out after 5 or 10 minutes. He really develops a strong relationship with each patient, working on rehab in addition to the adjustments. He would never aspire to have a practice where it was high volume and people, 3 at a time waiting in the wait room. And so as we thought about this configuration, he doesn't have any employees. I don't think this setup would work for any chiropractor in the future who was hoping to expand into a really high volume practice where they had multiple doctors and, many, many patients coming and going. The whole structure of having this home office is that, this is minimalist, and that is, how Ben believes he wants to practice for the foreseeable future. And so I just don't think this type of arrangement would appeal to a chiropractor in the future who thought, I'm trying to see 30, 40 people a day.
No, so noted. Appreciate the explanation. Back again to Counselor Lucas's question. We've lost the site plan, which is.
Would you like that
simple.
back up?
Well, sure. I mean, it's simple.
Okay.
The
Ms.
parking
Kemen, if you could
space,
put the,
parking space
Total.
number 5. Is there,
okay.
is it possible to structure this so that a car parked in 5 could exit without other cars moving, whether it's, any?
I can say, as long as there's no one parking in spots 1, 2, and 3, then the person in parking spot 5 can absolutely exit.
Okay, so
Yes.
so 4 and 5 could exit as long as there are
Absolutely.
any other cars.
If you look to the left of the screen, that's how our that's how our existing parking conditions are, and that's how we park side by side. Even though it doesn't look like there's enough room, there is enough room.
Right. That's why I asked the question. Okay, those are all my questions. Thank you.
Okay, thank you, Counselor Block. Counselor Roach.
I want to start by acknowledging the concerns that the neighbor had about privacy, about a business next to him, and change to the character of the neighborhood. Those are legitimate concerns. I may not share them, but I want to acknowledge them. It can be difficult to give public testimony and not hear any feedback on your testimony as a person who's done it. I look at this and have a slightly different take on this, which is this home office is a very special snowflake for a very special opportunity. And it seems to me that the petitioner is creating something unique for themselves, and that it will probably not have great market value to somebody else because of the nature of the parking. So I'm less concerned that we're causing a problem for some future business. Once they sell, that's the petitioner's problem. And if the petitioner can make the parking work, God bless them. Now, the thing about it, which I think is the concern that's underlying this, is the alternative to this parking situation is to park on the street. And that doesn't bother me if if it's required for the petitioner's business to work. You know, there is on-street parking available. I've been on this street a whole bunch. It's rarely parked up. So I don't think that it would have a substantially negative impact on the neighborhood, because I think in fact what's going to happen is patients will park on the street. Otherwise, there's no aspect of this that causes me any concern, and I'm prepared to vote yes.
Okay, thank you. I understand that there are no parking restrictions on the street currently.
Correct.
And the street, it looks to be about 20 feet wide. It looked like it was, especially with the snow, that it would be, it's narrow. It's a little on the narrow side.
Right now it is?
Yeah.
Yes.
I'm going to continue to take comments and also allow us to respond to your neighbor. But I see Councillor Delmabad has his hand up, and he's also a Ward 4 councillor, so I'll go with him.
Thank you, Madam Chair. And I want to thank everyone who's presented tonight. Yes, as you mentioned, this is both my ward and my neighborhood. I live just one street over on Regina, and am very familiar with Melrose, having spent the better part of 25 years going up and down it. And I just wanted to say that I think it's very exciting and quite interesting to see an ADU being proposed in our neighborhood, and this particular mix of bringing a small home business to it to help make it feasible, I imagine, is quite exciting and interesting to see. And as it happens, my driveway works exactly this way. We have 2 spots at the end, and you have to kind of shuffle a little bit if you want to get the one out. But it has generally worked out for us over a long period of time, that we've never owned more than 2 cars in the driveway here. I guess I have a question or a point of clarification. I heard Mr. Temple earlier say that the home business is allowed by right, and my understanding is that an ADU is also allowed by right. And so am I correct in understanding that if the home business were being proposed inside the primary dwelling and the ADU were being proposed as a standalone ADU without a business inside it, there would be no relief needed here? Is that correct?
That generally is correct. The home business, if it was inside the main structure, assuming it met the size requirements, would not need relief, and the ADU would not need relief. It doesn't need relief now. There would still be the need for relief for the 2 parking stalls in the side setback, and I'm happy to defer to planning if they have thoughts on that, but I think that's right.
Understood. Okay. Thank you. That's helpful.
I would just
Go ahead,
add,
Ms. Berman.
Attorney Temple is correct, and that the parking stall relief, if they needed to add parking stalls, that would be relative to the square footage of the home business. So it would be a calculation on how many stalls would be required and if they would need to add those into the side setback.
Understood. Thank you very much, Ms. Berman. So understanding that, and that really the reason this has come before us is because of this combining, it seems, in this way, and because of the parking relief that's needed. Helps me to kind of understand that though it seems a bit unusual, it's perhaps not as unusual as it might seem. And I also want to associate myself with the comments of Councillor Roach, recognizing Mr. Marchand, our new neighbor in the neighborhood as well, and his concerns about privacy and all of the kinds of things that come with having a neighbor doing something new next door to you. It seems to me like this is a reasonably scaled project. And as I said, it seems really exciting to have the opportunity to bring an ADU to our little Melrose Street neighborhood. So thank you for giving this some work and some thought.
Thank you, Councillor. I'm going to recognize Counselor Albright.
Thank you, Madam Chair. As everybody already knows, I guess, Dr. Grace is my chiropractor. And I wouldn't have known about this project, but I called for an appointment today and I found out about this land use meeting so that I felt I had to come and speak. This Dr. Grace runs a very efficient business. He does only take one patient at a time. And I think the most I've ever had to wait for an appointment was like roughly a minute. So it's already a well-scheduled business. It's a quiet business. And the fact that it's actually going to create another housing unit, a reasonably small new housing unit in Newton, is definitely a benefit. To the gentleman who spoke about worrying about how its effect on his property and his, his livelihood and his home. I live next door. For the first 25 years of my 45 years living in my current house, I lived next to a psychologist who had a home business, and he used to see patients, psychologist saw patients in an office in his home, and there was no waiting room in his home. And when patients came early for a meeting, they would sit in their car and wait until their meeting would start, and then they would go into the house. So it never bothered me. They're sitting on the street. It never bothered me as a next door neighbor. The other interesting thing that you should hear is that when that family moved to Brookline, they moved out. Another family moved in, and the husband of the house was a dentist, but he chose not to use that office. So there is no office in that house anymore. So it doesn't necessarily mean that when Dr. Grace in his old age, and he probably never should move out of that house until I'm long gone, because I need him as my chiropractor. When he's moved out of that house, it doesn't necessarily mean that that house will be used with an office in it in the future. So that's all I want to say. He's an excellent chiropractor. He's done wonderful things for my back. And it will cause no problems for the neighbor, I'm pretty sure. And the parking will not be a problem because it's already scheduled as one patient at a time. So I think the Land Use Committee can feel comfortable in that. Thank you very much.
Thank you, Counselor Albright. Sorry, Counselor Farrell, did I miss you? You had a hand up? Why don't, go right now, I'll recognize you. Thank you.
Thank you, Chair. Parking. I'm missing why you're looking for 5 spaces. If you've got 2 for yourself, you're not required any for the ADU, and you're required 2 for the business Wi-Fi.
I think this might be a better question for planning.
Yes, I think so. I think they don't need any relief
Whomever.
because they have all that parking. Okay, Ms. Berman.
Yes, thank you, Madam Chair. So the home business actually requires 1 parking stall per 200 square feet of the home business. And because the home business square footage is 625 square feet, that would bump him to a requirement of a total of 4 stalls. But the Newton zoning ordinance allows you to deduct 1 stall if your home business requires more than 1 stall, which his does. So that ended up totaling out to 3 parking stalls for the home business, in addition to the 2 parking stalls that are required for the primary dwelling. So that's where the 5 stalls came from, and that is also why, based on the site plan that you saw, that the petitioner is not needing to request relief, special permit relief for the required parking.
Okay, thanks. I must
Sure.
admit my head is spinning on that one, but I notice that there is a stairwell, an exterior stairwell to the ADU unit, which doesn't show on your west elevation outside. So I'm just curious to know, and maybe this would help with the parking. If you move that stairwell inside, would that completely diminish or terribly diminish your space for your
Let-
office.
Ms. Kamic, could we bring up the map again?
Yes, give me one moment.
And like to see where that stairwell is that Council.
It's,
Are you referring to this?
yes, yes, I'm
Oh, the-
referring to
The
that.
stairs, okay.
And just thinking about the neighbors' concerns and interests, one thing occurs to me that if you move that staircase inside, would it diminish beyond capacity your ability to have a home office? And also, might it reduce the square footage that would not require you to have a fifth parking stall?
So the stairs that you see on that drawing are a secondary stairs that are required to go to an ADU. The primary stairs are directly to the right of the entrance to the chiropractic office, and those are inside stairs.
Wow, I didn't notice that on your interior plan of the rooms plan. I didn't notice that.
Just clarification, those are required by the fire department?
Correct.
It's a secondary exit, which is literally next to the primary exit.
No, it's on the exact opposite side, so south and north elevation.
Okay, this, I'm confused by this, not seeing the design, interior design, which you had plans for. So for your neighbors' concerns, one is this is not a primary stair. You're not going to have people tromping up and down on the stairway.
Correct.
Okay, thank you. I didn't notice that. Interesting. Also, is there a covered, is the entranceway covered? You have all these diagonal lines on your rooftops and so forth. And then there are more diagonal lines.
No,
over-
that's a bluestone patio.
Pardon me?
It's a bluestone patio.
Oh, okay. So the parking spaces are, those two parking spaces, in fact, cover part of the bluestone patio?
No, they're right in front of it.
Exactly.
They go up to it. Don't they look like they're shorter parking spaces than the other ones along the side?
They're 9 by 19.
Okay, 4 and 5 are 9 by 19, and 1, 2, and 3 are 9 by 19?
Yes, sir.
And they're all in the same direction?
Yes.
Those hashed lines, that's bluestone.
The black lines directly to this top of the screen, right in front of the green parking stalls, is bluestone patio.
Okay, so that's why I'm asking what those hash lines are. I don't understand what those are, because they're the same hash lines you have on the roof of the house and the roof of the garage on the other side of the storage.
The pink diagonal hash lines are where our driveway will be extended. So
Right.
there's a
So-
slight,
I'm just looking at the black lines that cover half, what appear to be half of the parking spaces, 4 and 5. There's pink.
they're pink, and
Ah.
that's where the driveway is being extended. We have.
I mean,
a
I'm
slight-
losing my color definition also. All right, thank you. Yeah, I just didn't notice that that was pink. I should print this out larger format.
Counselor Farrell, do you have any other questions?
Oh, God, I think I've gone as far as I possibly can, but thank you very much. I appreciate it.
I see Counselor Maliki has her hand up.
Thank you. It's always been my understanding that with special permits, we're kind of looking at taking a long view and not looking at what this particular applicant is going to do with it, or who is going to live there, or, whose grandmother is, doing what. So my concern is actually not with the applicant's home business with its spaced out appointments, but it seems that if we're creating five spaces, 4 of which are in the setback, a future owner, they could be a family with 5 cars or whatever, and that's a lot of shuffling in and out and musical cars going on next to that side of butter. So that would be one of my concerns. Also, not crazy that they're putting the exterior staircase appears to be in the setback, which might be legal, but it's not a friendly thing to do, I think, to use up some of that setback space with the exterior stairs. And looking at the floor plans, I don't know if the fire regulations require that the secondary egress be like on a different wall than the interior stairs, but it seems like the entrance to the home office, I guess, seems like it's dead center. And if you flip the mirror image, the layout of the garage or office / ADU, you could have the interior stairs on the north side of the building inside, and then the exterior stairs on the south side, so that they would be, visible from the applicant's yard and not the next door neighbors. So, and also, I'm not quite clear on it looks like, I don't see any exterior elevations, but it looks like the one that's shown is kind of a profile, and it looks like it's 3 stories in the rear because of the change in the drop in the hillside. Is that correct?
Madam Chair, I'd be glad to respond to answer.
Yes, please go ahead.
So you're correct, Councilor Malarkey, that the elevations do in fact change. And from the rear, the building does appear as 3 stories. However, given the elevation measurements for the average grade, the basement is below the proposed average grade. So it does not count as a 3rd story.
So there is a basement below the office level?
Correct. And a portion of that square footage is included in the FAR. You'll note on the FAR sheet that approximately, I believe it's 318 square feet is included in their FAR calculation to account for the fact that a portion is exposed. But given, again, the proposed average grade relative to the midpoint of the basement, it doesn't count as a full story.
And can you comment on the business with the exterior stair being in the setback?
You were correct that I believe the stair on the exterior is a secondary means of emergency egress, and that is required for code. In terms of the placement, I do believe that the inspectional services prefers that the stairwell be on an opposite location to what's interior. However, I can't speak necessarily to the design that the petitioner chose to have the stairwell in the setback. It is allowed. And I'd also just note that the structure itself, inclusive of the stair, is still further from that northern line than the existing structure is, than the existing accessory structure is. So it still is moving further from that side setback.
I guess from the neighbor's comment, it sounds like the current accessory building is, even though it's closer to the property line, it seems to provide more privacy than the proposed design would. So I guess my suggestion would be to flip the layout so that given all the other stuff you're requesting to put in the setback with the parking and the cars, potentially that could be a future owners could be using them differently, is to at least put the stairs on the south side of the building, the exterior stairs on the south side and the interior stairs on the north side. Thank you.
Thank you, Councilor Malky. Are there any other questions from the committee? Councilor Block.
Thank you, Chair. I have a thought that I'd like the petitioner's reaction and perhaps the other members of the committee whether we could consider approving relief for one of the parking spaces so that officially this would be approved for 4 parking spaces instead of 5. That's just a thought that's occurring to me, sort of in light of Councillor Malaki's correct point that we need to take a longer view. It isn't just the appeal of the current owners
Yeah.
of the property. Sounds like
I think that's an excellent point to make. I was thinking the same thing, and I also have some comments. I'll let Councillor Lucas go first.
Thanks. So with respect to relief on the parking stalls, that would have to be noticed.
Yeah, we couldn't
And
approve
we
it
would,
tonight.
yeah, we would have to, they would have to kind of start over because they would have to apply for that waiver if they want to. And then it has to be noticed and sort of this whole thing starts over again. I believe that's right. I'll hopefully,
well,
finding our law, I'm not stepping on your toes.
no, thanks for that comment. Let's set aside the procedural hurdles and just deal with the substance of the thought. I'm curious about what people would think about that, as well as the petitioner, of course.
Okay, Councillor Farrell.
Thank you, Chair. And I really don't want to extend it. Well, I obviously do want to extend it because I'm going to extend it reluctantly. I just find how many additional square feet are in that office space that push us to a 3rd parking place?
I think Ms. Berman is looking that up, but if I could just make a point about the parking arrangement. So they, as you heard, they are required to show 5 parking stalls per the zoning. I think the parking requirements can be quite generous. However, say they did get a waiver of the stall, the amount of paving would remain the same. So you're sort of, it would just be the driveway, not a parking stall. So because they can show 5, that's what they're showing and it's compliant. But I don't know if Ms. Berman has your answer on the balance of the square footage.
I would be interested in that because I just think, I don't know how we got ourselves into a position where we don't have to provide parking for an ADU, but we have to provide apparently a lot of parking for a home business. The other piece is it possible to sell the ADU and keep the office down below?
I don't believe so because the ADU needs to be associated with the principal dwelling. And my guess as to why the parking is different is just, I think the provisions of the ordinance were just developed at different times. I think we've taken a much more recent look at the ADU than the home business. So it does seem like the home business requirements are a bit generous and perhaps contemplated having staff on site. It sounds like it's only the petitioner operating versus having a team or something.
I'm sorry, but if you're going to have an office that big, go to an office building. But what does associated with the main building mean? There's no connection.
No, they're
Literal connection.
held in common ownership.
Right.
You can't sell an ADU.
You cannot sell an ADU.
No, because it's accessory to the principal dwelling. So that's,
Yeah. All right. Fine. I think it's just really curious that we've gotten ourselves into this position. But if it's the law, I guess it's the law, but I don't particularly care for it in this case. Thank you.
Okay. I'm just going to make a few comments here. I did want to address the neighbors' privacy concerns as well. I do think there's a lot going on in this small space. I also think that you have too much parking, and even though it's required, a lot of our parking requirements don't always make a lot of sense. And my preference would be see reduced parking with a flower bed or some green space to be there. I understand that by right, you can do the ADU without having to come before us. And you can have your home office internal to the house and not have to come before us. So I just want to make that clear to the neighbor that could still happen. We have a lot here. We have a lot of purview over what happens in special permits. So my I tend to want to be able to get to yes, but I am sensitive to the context as well. So the privacy issue, the flipping the stair, or that appeals to me. Maybe some trees along the fence line, something that would, we haven't seen any, nor did I expect to see any like plantings or what other things you might consider doing. That would be one way to alleviate privacy concerns. We want to be thoughtful. I'm not sure if you spoke to your neighbors about this at all.
Yes,
You did, okay.
yes, yes, more than once.
Okay. The other thing is, you can't, can I ask the planning department, you can't Airbnb an ADU.
I would defer to Attorney Temple. We do have a separate short-term rental ordinance, so I believe you can't do rentals for less than 30 days, but I will defer to the attorney on that.
Yeah, I'd have to look at the ordinance. I believe under our new ADU ordinance, you're not allowed to do short-term rentals too, but we'd have to look at that.
Okay, that would just be one of my other concerns. I also noticed you are putting in new retaining walls under 4 feet, but just barely under 4 feet. So that is by right. But I would be making sure that you wouldn't go over 4 feet on those retaining walls. So those are just some of that everything that I wanted to look at. Yeah, the privacy issues, the potential for some additional cover or trees or something like that, too much parking, and what was the other? Could that, one other thing, the home office, could that be changed to additional, that would have to go through special permit to go, if they wanted to change the use, or could they even make it residential? Say down the road, how that I'm just thinking more long-term.
Yeah, I don't think there would be a path to convert the office into an ADU, or that would kind of impact the use.
Okay. That's what I thought. So if there's no other additional comments in committee, I see that Councillor Albright, you still have your hand up, or you've put it up a second time.
Thank you, Madam Chair. I hope you will not hold this petitioner accountable for what seems like some screwy rules that we have with respect to parking that don't make any sense. So I'm just hoping that, that the conflict, that we don't require parking for an ADU, but we do require many more spaces than we need for a home office, but that's not the petitioner's fault. So I hope you won't hold them accountable for that. And I can't help but say about the future, my mother used to tell me a story about a little girl who had a wonderful porcelain thing that she had on the mantelpiece, and she was crying because of this mantelpiece, this beautiful porcelain doll on the mantelpiece. And the mother asked the child, "Why are you crying?" And she said, "Because someday we're going to get a cat, and someday the cat will jump on the mantelpiece, and the cat will knock over that beautiful porcelain doll, and I won't have it anymore." And I think we need to worry about the present and not the future, and not cry about things that might happen 30 or 40 years hence. Let's let this petitioner do what they need to do and what satisfies the needs for our zoning. And I hope you'll approve this project.
Thank you, Councilor Albright. Is there any other member of the committee that would like to comment on this item? Councilor Farrell.
Thank you, Chair. Just talking about screwy rules, is there any way we could say that all of the windows on the north elevation be frosted glass? Thank you, Chair, for the indulgence.
We're getting into the minutia here. What does planning think about that?
I would defer to Attorney Temple on whether that's a reasonable condition or not.
Attorney Temple? Frosted glass. This would be on the upstairs, facing them. Well,
Yeah, it's not one I think we've ever really entertained before from a condition perspective. We don't usually touch kind of the design of the facades. Um, I can't say definitively you can't do it. It just doesn't necessarily seem consistent with what this committee's done in the
Right.
past.
It seems like we decide what color we're going to paint their house. Counselor Block,
Well, I'm ready to make a motion.
if you can keep it to 30 seconds. Usually I only have one one person make public comment once. Go ahead, speak into the mic.
In the design, there is a waiting room. This is a business. This is an ADU, and it'll be establishing the fact that the ADU is set up for a business. And so the dwelling part is secondary. I just want to make sure that I was represented to me that it's 10 to 14 people per day, strangers, that'll be walking through my yard, which is not consistent with the characteristic of a residential neighborhood. So that is my position. I think you'd be setting a precedent for an ADU that would lean towards business as the primary option and not the dwelling. So that is my case.
How would they be walking through your yard?
Sorry. So I apologize. I'm very excited. My property abuts the driveway. Driver's side doors are on the left side. They're all going to be parking there. They're going to be exiting onto my property. If you want to put trees to give me privacy, you have to put them on my property. You're going to have to then use my property to get this proposed relief. So that they will be walking to the entrance right past my patio with a direct view to me where we have our Adirondack chairs. So I'm just saying, in our direct site, it's noise, it's frequency, it's all day, it's a business, it's to make money. So like it will be there every day, every week, forever, right? For
Okay.
me. And that is not a residential situation. That's all I have to say.
Thank you. Just one more question for the petitioner. My understanding that there is a fence, does it not go the length of the property down towards the end of your driveway?
It does not go along the driveway. It essentially starts currently at the end of our existing garage, but the new structure is getting pushed back 13 feet. So it will actually align with
Counselor Lucas, do you have a comment?
So I asked a question earlier about the fence, and I believe you said that the fence goes the entire length of the property.
Sorry, we misunderstood. It goes the entire length of the property towards the back. It doesn't go along the driveway.
Could we bring up the map one more time just so we can see? Is there room for a fence to go there?
It would be on our neighbor's property.
It would be on the line.
Or the line.
There's definitely room for a fence on the line. No, our line.
Okay. So I heard, is there any other comments from the committee? I guess we can take the map down again so I can see everybody. Yes, Councilor Farrell, could you speak into the mic, please?
I thought the reason to pull it up was so that we could look at the driveway along the property line.
Well,
and whether people getting out of their cars would in fact be walking on the neighbor's property.
Okay. So could we see that again one more time? I was looking more to see if a fence could fit there. Will they be walking on the neighbor's property when they get out of their cars?
No.
The entrance to the new dwelling is smack in the middle of that dwelling.
The 9 by 19 parking stalls, there's still sufficient room on this side that they would not be on our abutter's property at all.
I'd like to hear from planning on that. And Councilor Farrell, just give me a moment.
Madam Chair, on the petitioner's updated site plan, they dimensioned the curb cut opening as 14 feet wide, which I also think if you look at the dimension of the parking stalls, the 9-foot wide the 9 by 19 foot stalls are dimensionally compliant. I would think that, you know, I mean, I guess it's possible that they could step a foot on a neighbor's property. But I think I mean, I really wouldn't know how to like say definitively either way. The cars are parked on this property, so
It could depend if it was like a very large SUV or truck versus a smaller car. I mean, 9 feet, that's pretty wide. That's
yeah.
dimensionally, okay. Okay, Counselor Farrell, thank you very much.
Thank you,
Ms.
Chair.
Urban.
Very quickly, it appears to me that if you open the driver's door on either parking space 1 or 2, and there were a fence there, you'd be hitting into the fence. I
Yes,
could be wrong.
I think I'm understanding that by looking at the design there. Okay. We could take down the map again. Thank you very much. Counselor Farrell, was that your comment? Okay. Is there any other further discussion on the committee? Any motion?
Yes, I'm prepared to make a motion. In the spirit of there is no such thing as a perfect plan, I'll move to close the public hearing and move to approve.
Okay. Any comments? No, okay. So let's look at the board order, please. Oh, yes, please close the public hearing. That,
I'd
Did you do that?
move that.
Oh, sorry.
You just take a voice vote.
thank you. It's getting late. Okay, regarding the public hearing, let's vote on that. And
Oh, sorry.
sorry.
I'll
just
go ahead
gonna
and
vote on
take
the
that down. Apologies.
Vote on the public hearing.
Aye.
Okay. Aye, closing the public hearing. Okay. Any abstentions? Any nays? Okay, so we see the board order.
Yes, go ahead and pull that right up, Madam Chair. Oops, I apologize. Pulling up the wrong thing now. It's getting late for me too.
Yes,
Hold
we
on
have
just a
one more-
moment.
We have one more item.
Sure. Okay.
This took longer than I thought.
Thank you for your patience. My apologies. So we have here the draft order for 224 Melrose Street. It's a site plan, a special permit site plan approval to construct a 2-story attached accessory building, or sorry, detached, excuse me, with an office for a home business on the 1st story and an ADU above, a home business that exceeds 30% of the ground floor area of the dwelling, and to allow more than 2 parking stalls within the side setback. Here we have the findings. Itemized is item 1, that the site is an appropriate location for the proposed 2-story accessory building as designed, as the relocation of the proposed structure brings it into compliance with the primary dwelling's dimensional side setbacks. Item 2, that the detached accessory building will not adversely affect the neighborhood, as the relocation of the structure further away from the northern lot line will increase the distance of the structure from a residential abutter. Item 3, that the detached accessory building will not be a nuisance or serious hazard to vehicles or pedestrians, as the structure is set back behind the primary dwelling and set back from the street. Item 4, that access over streets is appropriate for the types and numbers of vehicles involved, as the proposed driveway expansion allows sufficient space to meet the required number of dimensionally compliant parking stalls on site. And item 5, literal compliance with the number of parking stalls allowed within the side setback is impracticable due to the dimensions and configuration of the existing driveway on site, which allows for dimensionally compliant parking stalls arranged in a tandem order. We have here the details of the petition, the number, the petitioner, and the owner. The location is 224 Melrose Street. That the use will remain a residential use. And that the special permit relief will be to allow the home business as an attached accessory building, to allow a home business to exceed 30% of the ground floor area, and to allow more than 2 parking stalls within the side setback. And the zoning will remain a single residence 3. And finally, subject to the following conditions, we have our standard plan referencing condition here. We have our standard building permit condition, and finally, our standard certificate of occupancy condition. I'm happy to scroll over anything else if anyone would like to look at anything further.
Thank you, Ms. Berman. I don't see any hands up for any additional questions. So could we please call the roll?
Counselor Block,
Aye.
Counselor Farrell,
With the hope that you will give every consideration to your neighbors' concerns, I vote aye.
Counselor Golden, Counselor Irish, Counselor Kelly, Counselor Leary,
Aye.
Counselor Lucas,
Aye.
Counselor Roach.
Aye.
The motion passes with 5 yeas and 3 absent.
Okay, thank you very much. Our last item. This is.
I can pull up
time.
the presentation here.
This is 1626. It's a request to exceed FAR and to allow 3 stories at 89 Redwood Road. And welcome back. We know you were here before. So I'm going to have planning give their presentation, and then I will ask the petitioner to give their presentation.
Good evening, everyone. My name is Zach Melcher. I'm the planning associate for the city of Newton. I'm presenting petition number 16-26 for 89 Redwood Road, which is a request for special permit / site plan approval to raise an existing split-level dwelling and construct a new 3-story single-family home.
All right, could you speak a little more slowly, Zach? That would be
Yes,
helpful.
sorry.
And just take your time. And you're slightly muffled, the quality of the sound.
Sorry about that. Let me see
No
if I
worries.
can.
Just speak a little more slowly. Thank you.
Yep. The petitioner is seeking relief to exceed floor area ratio and to allow 3 stories within a single-family dwelling. The property is located in a single residence 2 district in Newton Center and is improved with a split-level dwelling constructed in 1952. It's situated in the Oak Hill neighborhood, which primarily consists of single-family homes. Most of the surrounding properties appear to be 2 or 2.5 stories. In terms of the relief, the petitioner is seeking relief to exceed 2.5 stories in a single-family dwelling and to exceed the allowable 0.35 FAR. The height will increase from 22.5 feet to 33.7 feet, but will still remain below the 36-foot requirement. And this proposal complies with all of the other zoning requirements. And then we have the standard special permit criteria, which I will go through. The proposed dwelling, which exceeds the floor area ratio, is not in derogation of the size, scale, and design of other structures in the neighborhood. The site is an appropriate location for this 3-story dwelling, which exceeds the FAR. The proposed 3-story dwelling, which exceeds the FAR as developed and operated, will not adversely affect the neighborhood. There will be no nuisance or serious hazard to vehicles or pedestrians, and access to the site over streets is appropriate for the types and number of vehicles involved. The dwelling presents as 2.5 stories from the street level, which is in line with the scale of surrounding properties. The building is classified as 3 stories because the midpoint of the basement is slightly higher than the average grade. And in this case, the basement counts towards FAR and counts as the first story. And this is a returning proposal, and the petitioner made changes to the plans based on the committee's feedback, which are the FAR will decrease from 0.50 to 0.47 through reductions to the deck and basement areas. The deck is being reduced by 90 square feet, and the basement living area will be decreased due to the replacement of the bedroom and the storage room. Additionally, the existing driveway will remain, which changes the increase in impervious surface area from 898 square feet to 364 square feet. And the footprint of the house will be shifted to ensure that existing trees are not impacted by the proposed construction. And that wraps up the presentation. I will return the screen here.
Okay, thank you very much, Zach.
Yes, sorry.
I'm going to turn to the petitioner now, see if there's anything else you'd like to add, if you have a site plan you'd like us to look at, whatever.
Yes. Just waiting to share.
And if you can make sure that you speak into the mic so everyone online can hear you.
Absolutely. I'm just waiting to share. I'm waiting for approval.
Okay.
You can share your screen.
Oh, great. Thank you. All right. Well, I appreciate you guys staying up and awake so late. My name is Victoria Sorotin. I'm a very long time resident, along with my husband, our children, my parents of Newton. I'm a committee member on Oak Hill Park Committee, and we are the current owners of 89 Redwood. On January 6th, as you mentioned, we were in front of this committee asking for relief for the hardship created by the site conditions at 89 Redwood. At that meeting, the committee asked us to return with the revisions to the following: reduction of impervious surface and driveway size, landscaping and tree plans, stormwater management and grading details, and consideration of the overall building size and FAR impacts. We were asked to come back here again, responding to these comments from the previous meeting. We took into consideration all of the feedback that was given and have made the necessary adjustments. In response to the comments on impervious surface and driveway configuration, our updated plans show that the house layout was flipped and shifted towards the location of the original driveway. As a result, the existing driveway layout and the existing street curb cuts will entirely be reused. I apologize for my voice. It's 3 hours of no water. The driveway area, as Zach mentioned, has been downsized from 1,087 square feet to 636 square feet. The rear deck was also reduced by 90 square feet. And as a result, the original impervious area increase was reduced from 898 square feet to 364 square feet. Moving on to landscaping and trees, this slide shows the current landscaping on the lot. And identified with the arrows here, you can clearly see where the trees and shrubs are. And I'm happy to just kind of quickly review it. I don't know if you can see my cursor. No, oh, it's blinking around. So these are the trees that are to the left of the property. They have some shrubs in between them. This here is a tree that is in front of the property, in front of the house. There is a tree here, and then all of this is shrubs to the right here. So here on the left on this diagram, we're showing the overlap of the existing home in red and the proposed structure in blue. You can clearly see that no trees over 6 inches are being affected by the new layout. And on the right here, there's a clearer view of the proposed structure, and all of the existing trees will remain. So to address your concerns on the stormwater management and grading, I'd like to turn it over to our engineer, Edmund Spruhan.
Good evening, council members. My name is Edmund Spruan of Spruan Engineering. I'm a registered professional civil engineer in Commonwealth of Massachusetts. I have 18 years of experience in the industry, most of which have been working in the city of Newton. We were retained to complete the drainage design for 89 Redwood. Our analysis shows the existing lot with current single-family home generates approximately 5,500 cubic feet of runoff towards the lower portions of the site, the north and south sides, during the 100-year storm event. Under the proposed conditions with the new single-family home, the runoff is reduced to approximately 3,100 cubic feet for the same storm event. This is a 2,400 cubic feet reduction in runoff for the proposed conditions. No, we're good here. So yeah, right there. Thank you. We achieved this reduction through a robust stormwater management system, including a trench drain, at the base of the driveway to capture any runoff coming from the driveway to the street, inspection and pre-treatment devices, and 2 infiltration systems. These infiltration systems were designed to fully manage storm events up to the 100-year storm over all proposed impermeable areas of the lot. Overall, the drainage system exceeds the City of Newton stormwater management and erosion control regulations. In addition, we are proposing a separate infiltration system to manage any potential discharge from a precautionary sump pump in accordance with the engineering department's latest requirements. The basement also meets the required minimum separation to seasonal high groundwater, meaning it will not impact groundwater elevations in the area. Please. The proposed grading has been designed to carefully avoid blocking of any runoff coming from our higher neighbors and to ensure any runoff going to our lower neighbors has been reduced in accordance with city and state regulations. On this slide, you will see the subject property 89 Redwood, shown on the right-hand side of the screen. The depth from average grade to groundwater at 89 Redwood is 4.09 feet. You will also see 4 nearby properties that are directly in the same area and clearly shown on the map. 21 Lovett Road, 94 Redwood Road, 71 Redwood Road, and 54 Redwood Road. The depth from average grade to groundwater at these neighboring properties is significantly greater than at 89 Redwood Road, our client's property. This comparison demonstrates that the unusually high groundwater at 89 Redwood Road is a substantial hardship relative to other properties on this road and in the immediate area. At 89 Redwood Road, due to the high water level, the basement floor shall be elevated to avoid potential water contact. In this unique circumstance, the midpoint of the new basement shifts slightly above the existing average grade by 14.88 inches. As a result, the calculations are recognizing the basement as a story, making the overall perception of a 2-story house seem a 3-story. As the basement square footage is being accounted towards the total house square footage in FAR calculations, this pushes the calculated FAR value to exceed allowable. This slide shows 2 profiles of the same house, one with groundwater and one without. The profile on the left shows a typical condition with no groundwater hardship. The profile on the right shows the conditions at 89 Redwood, where our clients are facing unusually high groundwater for this area. In the left profile, with no hardship, the proposed house is shown as 4,500 square feet of floor area, 0.35 proposed FAR. In the right profile, the proposed design for the site, the same house, requires adjustment to make groundwater separation and results in 6,120 square feet of gross floor area, 0.47 FAR. This increase is due to the house being raised by 14.88 inches, solely to meet the requirement separation to groundwater. Even with the building, I want to finish with this, even with the building raised, the proposed design is still approximately 2 foot 3 inches below the maximum height allowed. If anyone has any questions on that, feel free.
Thank you very much for the presentation.
Sorry, I'm not.
Oh, you're not done? Okay.
I'll go quick. So this slide just shows when the previous owners requested a demolition and they were reviewed by the Newton Historical Commission of January of 2024. Carmine Petruzziello of Balafi Development attested that the house cannot be added on given the previous flooding issues and making this property an ideal candidate for a full demo, not a candidate for a renovation. The committee agreed and found that no historical significance on the property and no demo delayed was imposed. Finally, to address the comments from the committee on building size and FAR. As our engineers pointing out, that unique circumstances on this lot and the 14.8 inches that have brought us in front of this committee, if they didn't exist, the exact same structure would be within allowance. Because these 14 inches shift the basement for us, the FAR coverage occurs only because of the zoning technicality. And I did bring a tape measure. And I don't mean to belittle this, but we're talking about this much. Without the groundwater constraints, the basement would comply. And there was a comment earlier made, this is our snowflake. The project otherwise meets FAR intent, height, neighborhood scale, and does not change the massing or the neighborhood character. With that, we made further adjustments per this committee's feedback. The basement development area was reduced by 336 square feet by converting the space into an undeveloped, unexcavated area. This led to the FAR reduction calculations when the basement area is included into the FAR calculations. Total FAR was reduced from 0.5 to 0.47. Total FAR would be 0.35 if this basement was not part of the FAR calculations. And then this is a slide just to show the proposed house elevations, and you can clearly see the garage shift to the right. Per your comments in the last meeting, we stayed with the original driveway. And at the last meeting, we also received some questions as to the building size and the FAR of this proposed property. And I want to walk you really quickly through the streetscape of the recently developed properties, as well as their data and how it compares to us. This is 94 Redwood. This is right across the street. 6-bedroom, 5.5 bath, 6,300 square feet on a lot that's smaller than ours. 21 Lovett, 6-bedroom, 8-bath, 7,100 square feet. 54 Redwood Road, 6-bedroom, 7-bath, 6,600 square feet on 4 levels on a smaller lot than ours. 21 Redwood, 6-bedroom, 6.5 bath, 6,282 square feet on an 11,000, which is also smaller than ours. 87 Clifton, 6-bedroom, 6-bath, 5,299 square feet on a smaller than ours lot. 71 Redwood. And then this is my favorite, 50 Lovett Road, which just came up for sale, 7-bedroom, 8-bath, almost 8,800 square feet across 4 levels. This is the proposed, thank you. This is the proposed proposed property, 89 Redwood Road. As you can see, this is a true 2-story home. There's nothing in the attic. And if the basement was not being accounted by these 4 inches that we have to plead in front of you, obviously this would be somewhat different. And lastly, I do want to just close out. We had a neighbor that wanted to dial in and unfortunately had to attend a wake. She provided me with a letter, and with your permission, I'd like to share it.
Did it get emailed to us? No?
I don't know that. She emailed it to me. I can ask her to email it to you as well, but I do have it.
Just a letter of support?
Yes.
Yeah. Okay. Is it short?
3 sentences.
Is it very short?
Very short, yes.
Summarize? her name
Promise
and
Rock.
address
Yep.
and
So just in
likes it.
conclusion, again, I'm not going to reiterate all of this. We've hit every mark that the commission brought from the last meeting by making all of these reductions. Again, I'm not going to waste your time reiterating it. No trees will be impacted. The house was reduced. FAR was reduced. We're keeping everything.
You did everything we asked. I think when I saw that right away, I'm very impressed and I'm very pleased that you worked so hard on this. And I just want to give you a lot of credit for that.
Thank you. Appreciative. So this is the letter. Again, I'll read it very quickly. My name is Christina Axiotis. I reside at 29 Clifton Road. I was hoping to dial into this meeting. However, I needed to attend a wake. I lived in this neighborhood since 2009.
Oh, you know what? Stop.
Yep.
Okay. We can just read it.
Okay.
Okay. Okay, I'm gonna open.
Sorry, I'm gonna pass it over. Okay, no, go ahead.
Madam Chair, I'll defer, and if there's any questions, Mike Ross, I'm the attorney, I can weave my testimony in. I'll take a pause there and let you do a round or whatever you want to do.
Thank you very much, Mike. I appreciate it.
Sure.
What I wanted to do, actually, we need to open the public hearing. I think we kept it open last time. Right?
Yes.
And is there any member of the public that would like to comment? I'm not seeing anyone. So is there a motion to close the public hearing?
Chair, I move to close the public
Okay.
hearing.
Thank you very much. Any comments from the committee? Counselor Farrell.
Thank you very much, Chair. I appreciate this. As you know, my concerns initially were about the loss of another possible preservable, affordable house, and my concerns about the water, groundwater and stormwater concerns in this area. I had the opportunity to meet with Mr. and Mrs. Sorotin on January 22nd, and they presented all of these changes that they have just described in detail. I am very impressed with what they have done, the hard work they put into this, and at the appropriate time, rather than repeat all of the things that they have said that in response to all of our questions, I would, when appropriate, like to move to approve this proposal.
Thank you, Counselor Farrell. Counselor Lucas.
Thank you. Mr. Ross, good evening or good night. Did you hear that? I thought
Yeah.
it just, okay. So I'm looking at the prior planning memo. Lot coverage was 20.8%. I'm looking at the current planning memo. Lot coverage is, you guessed it, 20.8%. The only reason why you're here is because you're seeking relief for FAR in 3 stories. And that's because, as we discussed last time, of the very high water table. Is that right?
Correct.
All right, yeah. I apologize that we made you wait this long. I apologize for not opposing the motion to hold last time because I was ready to vote for it.
Sir.
So those are my comments.
Counselor Roach.
I too am very pleased with the changes that were made. I must say, the walk through the neighborhood and the enormous homes, this one included, blow my mind. I think he did a much better job this time of explaining the hardship angle of it. My original concern was what appeared to be kind of an indifference to the fact that you were in the house would be in violation or of a rule that the council had adopted for good reason. This felt a little bit more based in the conditions, so I appreciate that. I'm going to vote to approve, but approving these large homes gives me heartache.
That's a different committee. I don't see any other hands up for committee members or for other counselors. So the next step on my checklist is a board order. We already closed the public hearing, right? Oh, okay. Technically, we have to vote. You're right. Okay. So could we call the roll, please? Oh, okay. Voice vote on the closing the public hearing. I thought we had already done that.
No, we didn't.
Okay, close the public hearing, voice vote.
Aye.
It's getting kind of late. People are punchy. Okay, now the board order.
I'll pull it up here. Share my screen. Okay. This is the order for 89 Redwood Road, to grant special permit approval to exceed FAR and to allow 3 stories within a single family dwelling. And I will go through the findings here. The site is an appropriate location for the 3-story dwelling with a floor area ratio of 0.47 because the dwelling is at scale that blends with the existing neighborhood of single-family homes. The 3-story dwelling, which exceeds the FAR as developed, will not adversely affect the neighborhood as the proposed height is below the maximum allowable height for the zoning district and complies with all other applicable dimensional standards in the zoning ordinance, including setbacks, lot coverage, and open space. There will be no nuisance or serious hazard to vehicles or pedestrians because the project utilizes the existing curb cut and driveway, which provides adequate sightlines and access for those entering and exiting the site. Access to the site over streets is appropriate for the types and numbers of vehicles involved. The proposed addition, which exceeds the FAR, is not in derogation of the size, scale, and design of other structures in the neighborhood and is of similar in scale to the existing homes in the neighborhood. And then here we have the petitioner information, which is 89 Redwood Road, LLC. The address, 61 Brookline Street. It's for a single family dwelling. And the relief is to exceed FAR and to allow 3 stories within a single family dwelling. And for the conditions, we have the plan referencing condition, the building permit condition, and the final inspection condition. So with that, I will hand it back to the committee.
Thank you very much. I think it's time for our committee clerk to call the vote. Call the roll, rather.
Counselor Block,
Aye.
Counselor Farrell,
Aye.
Counselor Golden,
Aye.
Counselor Irish, Counselor Kelly, Counselor Leary,
Aye.
Counselor Lucas,
Aye.
Counselor Roach.
Aye.
The motion passes 6-0.
Hey, congratulations.
Thank you so much. Have a good night.